Good morning, everyone.
Good morning, everyone.
A very hearty welcome to all the participants today. NHA is pleased to conduct this workshop on land acquisition for national highways for the benefit of all. Firstly, today, now on behalf of all the participants, I welcome today's dignitaries to the dais. Firstly, Sri Vimal, GM Land Acquisition National Highways, New Delhi. Sir, please welcome onto the dais. I invite T. Yogesh E. Moth to please hand over the bouquet and welcome, sir. Colonel Rajendra Kumar Swain, Consultant
National Moth, New Delhi. Sir, please. I invite KVD Ranjini, DGM Technical, RO NHA Vijayawada to please invite sir. Shri V. Ramchandra, Engineering Chief R&B Vijayawada. Sir, please come on to the dais. I invite Neeraj Gupta ji, GM Technical RO NHA Vijayawada to please hand over the bouquet to sir. Shri R.K. Singh, CGM Technical and RO NHA Vijayawada. Sir, please welcome to the dais. I invite Shri Shashank Rai, EE Moth to please hand over the bouquet to sir. And lastly, Sri G. Harikrishna, RO Moth Vijayawada. Sir, please come on to the dais. I invite T. Parvatisam, PD Amaravati to please hand over the bouquet to sir. Thank you, sir, all the dignitaries for gracing the dais. I invite all the dignitaries to please light the lamp and officially inaugurate this 2 days workshop. Thank you, sir. Firstly, I invite Vimal, GM LA NHA New Delhi to please offer his opening remarks.
Good morning, everybody. ENC sir, RO Vijayawada, RO North Vijayawada. This workshop is primarily planned to educate the field offices for regarding land acquisition. This is as per the direction of Cabinet Secretariat. They have earlier there was a presentation with CAPSEC where they directed that capacity has to be built with the field offices for land acquisition. There are many issues pending, so that's why these workshops are planned. This is basically 2 days workshop. The sessions are planned. One is regarding Act, your basic thing about the Act, NH Act plus RFCT, then the problems we are facing, then advocate related arbitration and these things. So today we will have a discussion with PDs and advocates regarding the various issues we are facing, plus tomorrow we have a detailed discussion on the Act, the issues, compensation calculation and other issues. So from Ministry, Mr. Swan is there. Bhoomi Rashi portal also we will demonstrate what are the issues. So we expect that there will be participation from all of the participants so that it is an interactive workshop so that we can learn from what are the issues fields are facing on this land acquisition and we can have a resolution. Plus if there are some changes at policy level also, we can consider that and that so that we can issue. Thank you.
Thank you, sir. Now I invite Colonel Rajendra Kumar Swainji for his opening remarks.
Good morning, ladies and gentlemen. Okay, I'm the LA consultant with the ministry, and I'm so happy to see you, so many people of you participating in this workshop. I must tell you, this is going to be such a awakening workshop. It is not only that we will be imparting knowledge to you. It's going to be interaction so that whatever problems you are facing at the ground level, that also should come up to us. So that when we are formulating any policy at the ministry level, at least we should be able to keep those things in mind, what are the ground realities which are generally our personals are facing at ground level. So mainly, I would say today, though it is mainly they have kept for the arbitration cases and the court cases, but tomorrow it's going to be a session regarding NH Acts and the other Bhoomi Rashi portals, which are going to be very important discussions. And I would expect all of you to come forward and participate on those discussions and whatever the ground realities, you people should bring it to our notice, because the law is a ever-evolving process. The NH Act, which has been made a law, after that, immediately after the NH Act has been made, they have started to make an amendment. Since 2014-15 onwards, that they are working on an amendment of NH Act, but till now that amendment has not come through. But at ministry level, nowadays, they are working very hard on to bring that amendment. In fact, this amendment was supposed to be brought in last session only, but somehow it could not happen. So we are working on that. If your inputs comes to us, we might be able to incorporate certain things in the new amendments. So my request would be, tomorrow when we people will be discussing on NH Act and Bhoomi Rashi portals, please come forward and discuss out your ground realities. And I wish you, all of you, a happy workshop for next 2 days, and at the same time you enjoy the hospitality which is being offered by NHI, RO NHI in this grand hotel Lemon Tree. And thank you very much. I look forward to a very good participation from all of you. Thank you.
Thank you, sir. Now I invite Shri V. Ramachandra, ENC R&B Vijayawada, to please offer his opening remarks.
Dignitaries on the dais, dear colleagues and my dear engineers. Good morning to you all, and I welcome you to this two-day session on land acquisition and NH Highway Act. This is a rare opportunity for all of us. Firstly, I thank RO NHI and RO Moth for organizing this two-day seminar. It is really a learning curve for most of us, and I sincerely feel you must grab this opportunity with both your hands, because it's a very rare opportunity, and we are getting suggestions or we are getting instructions from the highest level, that is GMLA, the topmost level in Delhi. So kindly grab this opportunity and interact freely and clarify all your doubts, because we are taking up national highway projects, grounding of the projects on the success of the projects. Any delay in the land acquisition not only increases the cost, but increases the arbitration cost in the arbitration also. So land acquisition is a very, very important aspect of the land acquisition. So I request you all to kindly participate actively and share your experiences and gain their suggestions, take their suggestions and go forward. And I feel you must be very much enriched with your knowledge of land acquisition after the 2 days of seminar. Thank you.
Thank you, sir. Now I invite Shri R.K. Singh, CGM Technical and RO NHA Vijayawada, to offer his opening remarks.
Good morning to all dignitaries at dais and my friends and colleagues attending this workshop. As we all know, this workshop will be a milestone in expediting the land acquisition in the state of Andhra Pradesh. Though we all know that we are working hard and we are having good licensing with the state government, like my PDs and executive engineers are having in the state district level. I am coordinating ROMRTH, we are coordinating at state government level, and we are getting good supports. What is lacking, what I feel, what is lacking within us, we have to understand. We should have the deep understanding of our provisions under NH Act, under FLAR Act, and there is a manual of published by ministry, just clarifying all the provisions and different court orders, opinion of ASG. So I request all of you to go through all these three things only. And there are certain circulars which have been given through pen drive to all participants. You please go through whenever you get time, maybe on Saturday or on Sunday. And if you understand the things, then it is your responsibility to make understand the kalas, because mostly the kalas, and we also organized this workshop last year also. So we have got good results. So until unless we understand the provisions, we cannot convince the public, as well as we cannot convince the Kala also. Similarly, we are facing different issues at the level of arbitration also. Sometimes arbitrators are giving second awards, whereas their predecessor as an arbitrator has already given awards. Nobody can revise the award. Likewise, Kala is also revising its award. So all these things we have to understand. And what I have felt, mostly we are having issues with the nature of land. So nature of land, we have to impress upon the Kala and collector. We have to go as per the documents, as per revenue documents. We cannot go beyond that. Otherwise, what Kalas arbitrators are feeling, they are comparing it with the nearby land that is having major potential for development. So all these things, okay, we can see, we can feel at the ground. But while we are exercising our powers in the NH Act, we cannot agree to all these whatever Kalas are giving justifications. So as a RO, as I am competent authority for taking decision whether to accept the Kalas award or to challenge the award before arbitrator. Similarly, against arbitrator award, we have to go to the district court or not. So this decision has to be taken by RO. So I cannot take the decision if it is having some deviations. Though as a via media, NHI has also given a circular for taking advice from the Kalas, from district collector against if there is some deviation by Kala. Similarly, against arbitration award, if there is some deviation, then I can go to the state government also for its advice. So all these are via media. So that's why I always stress upon and impress upon the Kalas, please you go through as per NH Act. As per section 26, you fix the market value, and accordingly you please give the award. If public is not feeling, is aggrieved by your award, they can go to the arbitration, and then after issuing 3 notices, we can take over the position of the land. So in this way, we can get the land, we can do the work. That is the main thing. Otherwise, if people going to the arbitration, they will go arbitration. We can be liberal, we can give 20-30% excess. That is not an issue for us. So again, my request is, experts have come from ministry as well as NHI headquarters. They will be presenting here about NH Act, about FLAR Act, some court orders. This time we have also invited our advocates. So we have a session for discussion with the advocates also, because advocate is also one of the most important link in our land acquisition process. Because so many things going to the arbitration, it is pending with the arbitration. Lakhs of the cases are pending in the arbitration. So we have a session on that also, how to reduce these arbitration cases. I have asked my PDs to please work out what is the reason why we have gone to the arbitration and what is the cost implication. If cost implication is not much, we can agree to it. We can give a proposal to the headquarter as a one-time relaxation we can obtain from the headquarter, and then these cases will be disposed of. So headquarter is also in such a mood. So we have to grab this opportunity, today's and tomorrow's workshop, and we have to understand the things. We have to educate ourselves, and we have to educate others also. Thank you. Thank you very much.
Thank you, sir. On behalf of all the participants, I heartily thank all the dignitaries for giving their opening remarks and initiating the thought process on this workshop. Now, I kindly request the dignitaries to please move from the dais to the audience so that we can start our first session.
మైక్స్ ఉన్నాయి టూ ఒకటే చెప్పారు. ఇక్కడ ఉంటుందా ల్యాప్టాప్? ఒకసారి అప్పుడు డిస్ప్లే చేయకండి ఒకసారి. క్లిక్ చేయకండి అప్పుడు.
ఇంకో దగ్గర ఆల్రెడీ ఓపెన్ చేస్తున్నాను.
ఇది పీపీటీ
ఇదేనా?
ఇది ఓపెన్ అయ్యింది సార్. మనం కాపీ ఇది ఇప్పుడు ప్రెజెంటేషన్ జరుగుతుంది.
ఇదే కదా, ఇంక వదిలేసాం ఇలా సరిపోతుంది అంతేగా.
నెక్స్ట్ అది సార్, నెక్స్ట్ అది.
టూ రెండు పెట్టు. టూ అంటే మళ్ళీ ఇక్కడ కనిపించి అక్కడే కనిపిస్తుంది. We will be starting the first session for today, that is compensation determination and its challenges. I heartily invite now Sri Vinay Prakash Chaturvedi, DGM Land Acquisition National Highways, and Mrs. Meenu Kushawa, LA cum Legal Executive, to please come and present the presentation.
A very good morning to all of you. After this wonderful opening remark, this is the first presentation I'm going to present. As per the plan, we have shifted the main presentation of NH Act and RFCT LR Act for tomorrow. And just for setting of a tone of this workshop, I have prepared something for you. Basically, compensation determination is the, which is something, it is delegated to the competent authority. Competent authority has to determine the compensation. He has the power, he has the delegation. What he will fix will be final, as per the Act. Now, in our for land acquisition for national highways or development of national highways, there is two provisions are there. Actually, earlier before 1st January of 2015, we were doing the land acquisition under the provisions of NH Act 1956, before the implementation of RFCT LR Act 2013. After implementing provisions of RFCT LR Act, that is scheduled 1st, 2nd, 3rd, in land acquisition process, the things have been changed. We do land acquisition under NH Act. We publish notification under NH Act, 3 capital A, 3D. We complete the process of determining the compensation under section 3G. But the principle, whatever we take from RFCT LR Act. As we are doing we are dealing this land acquisition from a long time. We all are aware about this, the provision of RFCT LR Act and NH Act. What I think, we all are aware. We know the provisions, we all are aware. How much we are aware, we are going to test it, okay? We already have some papers and pencil with you. I am going to see you some example actually. But before that, I would like to highlight something. What is the procedure? What is the basic principles under RFCT Act by which a compensation is determined? See, here is the picture. In 3G award, generally what we take market value of the land. And the set principle says that under the provision of section 26 of RFCT LR Act, we consider three things. First one is circle rate, whatever we call guideline rate, and the average of top 50 sale dates happened in last preceding 3 years, an average of consent purchase or consent purchase amount. Thereafter, we apply a multiplication factor, add the value of structure or assets attached with the land. Thereafter, we implement solatium, 100% solatium provision is there. And thereafter, we include additional market value. Additional market value at the rate of 12% on the value of land only. I think this slide has cleared the concept about the determination process, what we use. Now, here is something. I have taken this example, and this is totally imaginary. Don't go through the fact that I have just taken this for this workshop. See, a land acquisition was done in Etukuru. It is a town in Guntur district. I have taken a survey number XYZ1. The land area acquired was 100 square meter. Type of land and nature of land was private and residential site. 3 capital A notification was done on date 10th of March 2014. And the final notification, which is the 3D notification, was done on 10th of August 2024. Now, we are supposed to publish the award on 10th of September 2025. Here are the multiplication factor. As per the state government, the multiplication factor is fixed as 1. And guideline value is 8,980 rupees per square meter. And the attached assets value is 15 lakh. We are some sale deeds here. Sale deeds executed in near area, with a similar type of land. You can see that these rates. This slide is visible to the last sheet? No? Okay. It's okay. You can see this actually. You might stand and you can see this. I'm giving you just 5 to 10 minutes. Being a PD, being working staff with NHI and MORTH, we people should also know what is the basic principles of determination of compensation. So I expect that it will take hardly 5 minutes to calculate the final compensation amount. Are we ready? Are we ready? Okay, please start your exercise. You have the pen and your pencil. It is like putting yourself in someone else's shoes, because we are obligating Kalas for not determining the compensation appropriately. But are we ready in the position to calculate the compensation? How much we understand this act? There are 15 transactions, I think. I have already explained the basic principles. How much transactions we will take. Anyone there who has done? What is the market value for this land acquisition? What we will consider the market value? I should wait or move forward, actually. If we are really doing something, then I will wait. If we are not doing, then I will move forward. Okay. Sir has said I have to move forward because it is taking much time. Now, it is up to you. What I am thinking, you are the competent authority. You have the power, which transaction you have to consider under the figure, or you should not consider in that. Okay, you have the power. See, what I am saying. How competent authority determine this? How competent authority choose those transactions? On what basis he choose the transactions? That's why the determination of compensation is always challenging. Sir,
Okay, 17th December 2020, it is beyond 3 years. Okay, everybody please.
Now see.
The main thing is whether we have to discount this 11,500 or not. That is the main thing. This will differ from Kala to Kala. What principle I think, I have to take all 14 rates average and then 15% maximum. If it is beyond 15%, it will be discounted. As per my opinion, if it is within 15%, it will not be discounted. So it is a very close 11,000. I think it is almost maybe 18-20% or 14%. I don't know.
But it is not falling in the principle that we should take the transaction which has happened in preceding 3 years. Preceding 3 years from the
Date आप पहले क्या था आपका 3 है?
overall
It will be there, na?
it is there.
It is there. Now question is whether this will be discounted or not. I am talking about discounting. It is not eligible. 17, this first one is not eligible because that is beyond 3 years.
Yes.
But it will be discounted or not. This will differ from Kala to Kala. What personally I feel, I will take average of all 14 and then suppose 100 is the average. So up to 115, I will not discount. Beyond 150, if it is excess more than 115, I will discount it. Now, I don't know what is the average of all 14. Have you done it?
We have already discounted the last transaction which was happened on 27th of February. Because it not comes under the preceding 3-year transactions. What as per the act is, we have to consider those transactions which has happened in preceding 3 years from the year in which the land acquisition was proposed. Land acquisition is proposed. So we will not take the last transaction also. We will exclude that.
What is preceding years? Means you are taking financial year or calendar year?
No, calendar year. Calendar year. We are taking calendar year. We always take calendar year.
Okay.
Kala to Kala, what I said, it is a complicated process. Which transaction we should consider?
In act, I think it is written 3 years preceding.
Preceding 3 years.
3 years
from
preceding.
No. It is very much clarified. I can show you.
Preceding 3 years, na?
Preceding 3 years. But it is very much clear.
Clear nahi hai na? Preceding 3 years.
Hello. Acha, sir, let me clear it to you. The Act clearly says the year in which the 3A notification has been published, preceding that year. Suppose if 2024 the 3A notification, even if you have published in November, December, 2024 will not be taken. The year in which the 3A notification has been published, the preceding 3 years. That means in this case, if it is 2024, the 3A notification has been published, maybe it is November 2024 or December 2024. But you will take 2023, 2022 and 2021. That's what the ruling is. Baki Kalas, what they are doing on ground, that I think ROs must be knowing it.
If 3 capital A published on 31st December 2024, for example.
So
it means
he will go to
2024 we will not take anything?
Not be calculated. It clearly says, the rule says, the preceding 3 years in the year on which the 3-year notification has been. If it is on 1st January 2024, then also he will go to 23. If it is 31st December 2024, then also he will go to 23. That is clear.
Everybody please understand.
Is from the date of notification is the criteria for calculating the period, 3 years, preceding 3 years, not the year of the publication. It is the date of the publication important, because why we calculate 12% additional market value from the date of publication till the date of award. So that is the clearly said. Actually 3A notification date is the basis date, where from we have to go back 3 years.
Hello. Yeah. Interest calculation is different and determining market value is different.
Here is the explanation actually. In the act, here is the explanation. You can see
Banuji, I think he is correct. Colonel Stein is correct, because 3 years of the preceding 3 years of the year. So of the year means we will take calendar year. Means 2024, whether it is 1st January 2024 up to 31st December 2024, then we have to take 31st December 23 onward, backwards, 3 years.
There is a logic behind this. Because your circle rates are determined year to year basis. So that year circle rate may not have been determined up to that. That's why we generally take preceding year sale.
Suppose it is 1st December, first.
All of
But
year.
as per the act,
You have to exclude.
No, suppose it is 1st January 2024, then?
Then 23.
Then you have to take 31st
Yes.
December also, one day before.
Yes. One day also you have to take preceding year. Whole year also you have to take preceding.
चलिए anyway, ठीक है.
सर ये एक्सप्लेनेशन इसीलिए है, उसमें लिखा है, इट इज क्लेरिफाइड हियर कि किसको लेना है. उसमें लिखा हुआ है स्पेशली कि उसको हमको छोड़ना है, which was done in that year जिसमें लैंड एक्विजिशन प्रपोज है.
Any PD can tell what kalas are considering, how they are taking? So we have to
for all the acquisitions,
tomorrow
it is the date of notification the kalas are doing, sir. If we put this again, this may confuse them something, because the practice since a long time, the date of notification is the criteria for calculating the compensation, either downward or upward. Maybe
which notification we are
3 capital A?
3 capital A, not 3
A.
small a. Okay.
3 capital A. Because then that will lead to confusion. What my kala?
It is the discretionary power of kala. But what I am saying, this is written in the act. What the explanation is there. We have to left that transaction which was happened in immediately in that calendar year, and which we are proposing the land acquisition. We should exclude it. But if
You will need to educate kalas. Kalas cannot go beyond rules. The rules are rules. As per the rules, they have to calculate from the preceding years. If they are doing something like that, if somebody, we are not challenging. But the day NHI starts challenging, now you are doing a wrong thing, they will be in the dots. So that's why PDs, you people are the main persons who has to educate the kala. No, this is as per the rule, this is what it says. And you have to calculate it. They might be, I'm 100% sure, many kalas would be doing this thing, they would be taking this date of 3-year notification.
Anyway, we will discuss tomorrow also. We will discuss it tomorrow also with kalas.
see, in a very first stage, we got a lot of confusion. Huh? See,
one more thing, Chaturvedi ji, one more thing. You have to clarify how we will take discount. That is also a major thing. What we are, because there is nothing clarified
written in any act.
In RECFAR Act or NH Act. So how to discount it? What I have found in the manual somewhere says that guidance value may not be more than 10 to 15% of the average sale deed. Because based on average sale deed, our collector determines the guidance value and which is published by the registrar. So likewise, similarly, we can interpret that what is the total sale value, average, then we take average, and then up to 15% we can consider. Beyond that, we can discount. If you have some different idea, you please say.
No, it's okay, sir. It's okay. We will discuss it tomorrow. We have certain judgment on this, where the guideline value has been not revised since so long. In such cases, there is guideline of Supreme Court to enhancing the guideline rate by 7.5% to 10% by 10 to 15% in urban area. We will discuss it tomorrow. We will more clarify. Sir is saying something.
What sir is saying, how to get this 11th, suppose it came within your range, within December 23, then whether we will discount this 11,500 or not. That is the question, sir. But the thing is, here suppose there are 10 sale deeds, only one is regarding 11,500. Then we have to discount that because 9,000 around range is there. Then if it is around 20% outlier, then it has to be discounted. So, but if it is suppose 4 or 5 sale deeds are there, then we can take. But saying it is a single sale deed, so we have to discount.
My point is only there must be some defined methodology. How we will decide. Otherwise, it is on the discretion of the Kala.
Yes, it is.
Then also we cannot challenge.
But generally we take where there are maximum 80-90% sale deed are in a particular bracket. Then we have to take that only. Only 5 to 10% sale deeds are beyond that.
Now, excluding these 3 transactions, we will have 12 transactions. And further, what we will take? We will take top 6 transactions, and we have calculated the average, and it arrived 9,467. How much of you are agree with this? If someone has calculated it, then the figure must be this. Then in this case, the compensation of the land will be 9,46,700. Now going further. Yeah, definitely. The compensation for the land only, sir. Market value for the land actually. Now here, I am putting in the formula. Market value for the land is 9,46,700. Applicable multiplication factor is 1. The value of the things attached to the land is 15 lakh, as I mentioned earlier. Now we will impose solatium, 100% solatium on value of land as well as value of assets. It will be around 24,46,700. And then it comes additional market value. As per the clarification of manual, there is a provision under RSCT LR Act to including additional market value. So we have to include additional market value only for the value of land, not for the assets. So it will be around 1,70,406. Now the total compensation for the survey number will be 50,63,806. This was the exercise actually. We have seen this, that how Kala faced challenges. What are the challenges comes before him? How he considered the market value, if the transactions are available or not, which transaction he should consider, which transaction he should discount. These are the main factor and main challenges before the Kala. It is very easy. So checking someone else's copy. But when we have to give the examination, we better understand what are the situations, what are the problems, what are the challenges. Being an executing agency for development of national highways, we also understand what are the realistic picture behind the Kala, what the Kala is facing. Now, here are some issues. In majority of the issues, Non-availability of sale deeds. Do you think in agriculture area how common sale deeds, how generally sale deeds are executed? It might be one or two. If you will get in the field, you will find there are only in preceding 3 years, normally one or two transaction has been happened. Now, see, if there is no transaction is there, how Kala will determine? There is provision, he should see the near vicinity rate. Now, it is also challenging. Which area he should consider that vicinity, this is a near vicinity. It is also challenging. Now, second one is non-updation of revenue records. As sometimes actually change of land use has been done, but it has been not reflected in the records. It is also challenging because the person who has applied for change in land use and already doing some commercial use in the land, and now you are going to give the compensation on the basis of agriculture land. How he is going to accept that? It is also a challenging point. Non-updation of guideline value. In certain state, we have seen it since so long, from 10 years, even from 5 years, generally in 5 years or 10 years. The circle or guideline value has not been enhanced or not been updated. It is also challenging which value he should consider. Yeah, definitely, sir, definitely. in Tamil Nadu, in Gujarat, it was happened. Earlier, the compensation was high, and there simultaneously, when we executed the another award, it became down. People are again litigating for this. And variation in the multiplying factor. Sometimes state change the multiplying factor. Earlier it was 2, now it is 1.5. Earlier people got higher compensation. Now people, due to change in the multiplication factor, now they are getting lower compensation. It is also an issue. These are the challenges. These are the realistic challenges. How complicated a determination of compensation is. Now you are able to understand that. And the third one is consideration of genuine sale deeds. As we have already seen this in which transaction we should consider and which transaction we should discount it. People generally get, sometimes it happens, if somehow they get aware that some highway is going to be developed, they started doing fictitious transaction on the name of his son or someone else, just because of, in sake of higher compensation. If I will do this, then definitely the calculation will go rise and I will get the higher compensation. It is also challenging. Then being in Kala, being an authority who has to determine the compensation, these are also major challenges. Thank you. Thank you for this. Thank you for your time. Actually, this was the first presentation. We have already made a detailed presentation, which we will show you tomorrow, and which we will explain in detail the NH Act and RFCTLR Act by sections, with the provision, by the sections, by the schedule. Thank you. Thank you so much.
हमारे पास मेजर चैलेंज ये है कि आज तक ऐसे करके आ रहे थे, अब तक तो ये भी कर सकता है, जैसा आपने बता रहे थे सर, नवंबर में हुआ तो पिछले साल का लेना है, तो उन्होंने 10% 15% बढ़ा के दे सकता था टू कंपनसेट व्हाटएवर. that. आपने कैलकुलेशन में वन दिखाया है, assuming that it is urban or generally assuming that यहाँ का एक फैक्टर है करके तो इसीलिए वो एक लिया है, अदरवाइज यहाँ पे 1.25 है, रूरल में 1.25, अर्बन में 1 है, they can go, but यहाँ पे already notified as 1.25. That village you have shown is urban. That is why you have used one. Kutturu.
PDF no, madam. PDF no means.
But when to declare under urban, it should be in the municipal limits. You have the data of the municipal limits.
PPT means slideshow है मैंने ना. ये PPT not a problem. Okay. Okay, madam.
Actually, our first session is planned to be up to 12 o'clock, so we have still half an hour more. Someone can come and share their views on difficulties being faced in land acquisition. Stage is open, then we can go for tea break.
सिमिलर टाइप ऑफ मल्टीप्लिकेशन फैक्टर वाला करके, हाँ करके तो लीजिए आप। आर्बिट्रेशन के लिए जाएंगे, अगर आप नहीं करेंगे पीपल विल गो टू आर्बिट्रेशन, इस एरिया में इतना मिल रहा है। आपने उसको देख के अगर मान लीजिए सर यहाँ पे 2 लाख का हो रहा है और वहाँ पे नियरेस्ट में 30 लाख एकड़, सम मिसमैच 2 लाख का आपने ये रखा हुआ है गाइडेंस वैल्यू, लेकिन इसका विसिनिटी में आ रहा है 30 लाख। आपको देखना पड़ेगा, लैंड ओनर शुड नॉट बी, वो चीजें हमेशा ध्यान रखिए। जहाँ भी आपने लैंड ओनर को काटने वहाँ पे आपको अपने हमेशा देखिएगा उसको किस तरह फायदा हो रहा है, ये भी नहीं कि वो अननेसेसरी इसके ऊपर अभी तक कोई सवाल नहीं उठा रहा है, लेकिन एक्ट ये वो सर बोल रहे हैं कि गाइडेंस वैल्यू से ही अभी प्रेसिडेंट मुर्मू, द्रौपदी मुर्मू, उन्हीं के गांव एक केस आ रखा है उड़ीसा, 2 लाख रुपया पर एकड़। आपने कोई झारखंड के आसपास उड़ीसा का ये नहीं है, और जबकि पर एकड़ 30 लाख चल रहा है उसके विसिनिटी एरिया में, तो वो चीजें केस चल रहा है। अरे कोर्ट ने आर्बिट्रेशन वगैरह, आर्बिट्रेशन में लोग गए और कलेक्टर ने भी वो विसिनिटी एरिया का लेके वो रेट को 2 लाख वाले को 29 लाख पे बनाया। आपने उसका मेल वगैरह दिया था, आरोप को दिया तो आरोप मिनिस्ट्री को बताया। आपका अभी तक तो उस पर चल रहा है, 2013 से लेकर 17 तक क्लेरिफाई नहीं कर पा रहे। आप आगे प्रॉब्लम
Now we'll be starting the session on
Under NH Act, the arbitration is given in section 3G5, where appointment of arbitrator has to be done by competent central government under section 3G5 through a notification in official gazette for appointment of arbitrator. The provision of Arbitration and Conciliation Act 6 shall apply to every arbitration. Arbitrator is appointed under section 3G5, but the other provisions of Arbitration Conciliation Act applies to all the arbitrations under NH Act. Next. Basically, arbitration key mechanism. What are the factors considered for compensation? Both the parties, as well as the landowners, as well as the executing agency, whether it is NHAI, MORTH or NHIDCL, they can file arbitration petition before the arbitrator if they are not satisfied with the award of Kala. So the factors to be considered for arbitration is market value of the land, damage to standing crop or trees, loss of earning due to acquisition. So here the arbitrator has to decide about the quantum of compensation. He cannot decide on the things which are not included in Kala award. He can only add, change the compensation, enhance it or reduce it, whatever is determined by Kala. Next. Just before that. This is. Only the amount of compensation fixed by Kala can be challenged and not for not others. Land of property for which compensation has not been decided. So that cannot be included in arbitration. Only the amount of compensation for which type of land or structure has been included by Kala, that has to be subject matter of the arbitration proceedings. NHI does not specify any specific applies to arbitration under which there is a provision of 3 years of limitation period for filing of arbitration. Generally, arbitrators are entertaining the applications after 3 years also, which is wrong. They cannot do that. So many cases are filed on this. Next. This is the arbitration. Arbitrator appointed to decide the references made to him is expected to do within a period of 1 year. That is Arbitration Conciliation Act. There is a limit of 1 year in which arbitrator has to decide the applications. Arbitral award must be in writing and duly signed by arbitrator. The date and place of award should be mentioned along with the reasons for decision. It should be a speaking award. He cannot just say, I have increased the amount so much without any justification. It has to be a speaking award, clearly writing the decision, reasons for enhancement or reasons for lowering the value, and it should be signed by the arbitrator himself. Arbitrator cannot remand back the award to Kala for redetermination. He has to resolve the dispute and cannot remand back the matter to Kala. Arbitrator not bound with the provisions of Civil Code or Evidence Act, but have to follow principle of natural justice. So, usko arbitrator has to decide the award. He cannot remand back. In case arbitral award is acceptable to the authorized project agencies, the amount shall be deposited with the competent authority within 30 days or receipt of arbitral award. There is a provision in payment rules of NH Act where we have to deposit the amount if it is not challenged further within 30 days of the arbitral award. If it is challenged, then we are not supposed to deposit the amount and we can challenge in district court. Next. If either party is agreed by the arbitral, it may approach the court under section 34, 37 of arbitration considered in DJ or High Court. Application under section 37 against the award passed by, this is 34 application in the DJ court. High Court 37. Section 34, there is a judgment of Supreme Court in NHA versus M. Hakim, which says that quite obviously if one were to include the power to modify an award in section 34, no one would be crossing the Lakshman Rekha and doing what according to the justice of a case ought to be done. In interpreting a statutory provision, it just must put self in the shoes of Parliament and then ask whether Parliament intended this result. Parliament may very clearly intended that no power of modification of an award exists in section 34 of the Arbitration Act. The DJ court has no power to modify the award. Either they have to quash the award or they have to uphold the award. They cannot modify. Suppose the arbitrator has given some rate or some market value, DJ cannot change that market value. Either they will quash the whole award or they will uphold the award, or after that the landowner or executing agency can further challenge. But DJ court has no power to modify the award. Next. Limited power of review by arbitrator. The arbitrator can only correct clerical or any typographical error, any other error of a similar name within a period of 30 days. This is section 33 of Arbitration Conciliation Act, where arbitrator can change the clerical or typographical error, but he cannot modify the award. High Court or Lavad in NHA versus Musafir and others. Arbitrator in the instant case erred in passing the award dated December 27, 2019, May 19, 2020 and May 28, 2020. Since no statutory authority empowers the arbitral tribunal to review, modify its award. Therefore, the said orders are void ab initio and deserve to be settled. So arbitrator cannot modify its own award. It has to be challenged in DJ court and they can quash they cannot also modify the award. Either they have to uphold the award or quash the award. So there are the limitations of arbitration also and DJ also. Next. These are the basic reasons in NHA or NH Act where we are filing the arbitration cases. Dispute on market value. Generally this is the main dispute, that market value is more. This sale deed is not taken into account, just like we are saying that outliner sale deeds have to be discounted. But generally, this is the claim. Disagreement over land categorization, land record were not updated or land use was not done. Change in land use was not done. But demand is for change in land use based compensation. Landowner has known the consideration of structure. Some structure issues are there. This structure was there, but it was not considered. So these types of issue. Landowners claim excess or deficient land acquisition or error in boundary demarcation. Sometimes we have someone landowner says my more land has been acquired, but some other person's land is less. So there are dispute on this. Disagreement of over calculation and payment of interest, 12% also that additional market value and interest also, which is 9% on arbitral enhancement award. Joint measurement survey, incorrect joint JMS of land, where proper demarcation of land was not done or the structures were not recorded properly or trees, etc. Deficiency in service of notice to the affected land losers, where the Kala has not properly issued the notice for 3G3. There also some disputes are there that I have not received the notice and you have determined the. Kala cannot rectify the mistakes of clerical error or omission. Wherever there in our NH Act, there is no provision for Kala to change or correct the clerical or typographical error. In Arbitration Act, there is a provision arbitrator can in Kala case are the reasons. Next. This is the status of pending arbitration cases in NHA. In RO Vijayawada, it is 41754. Next. Format. Standard across the country, where the all details have to be captured. Format. Standard across the country, where the all details have to be captured, so that later on these issues, the disputes are not there. Proper documentation of assets by way of videography, photography, etc. with joint signature, that has been included in the JMS format which we have circulated. The compensation should be determined in accordance with the set principles, just like we have seen today morning. There was one example, so that has to be determined so that later on neither NHAI or executing agency nor landowners go to court for this improper determination. Engagement of competent and experienced advocate to defend the case. Since everything is as per act, and so proper legal experience advocates can be hired to defend the case. Next. Thank you. So these are basic is procedure for arbitration and what are the mistakes. We have a question session on what problems arbitration you are facing. Yes. Yeah.
Sir, actually, we have been told just a few minutes back
Yes.
that the arbitrator cannot modify the award of the Kala and he can only examine the aspect of market value and some other aspects that have been rightly told
Yes.
to us, sir.
Yes.
But here, in our practice, what is actually happening here is, sir,
Yes.
the arbitrator has been modifying the award passed by the Kala.
Yes.
He changed the category of the land. For example, sir, an agriculture land category has been changed to the top land abutting national highway or land or house sites like that. The arbitrator issued certain orders like that, sir, and we received in token a many number of orders like that in the recent past, sir.
Arbitrator cannot do. We will show you one judgment of Supreme Court also, where it is categorically said that there cannot be any change in land use without proper procedure. If that procedure has been followed, then only arbitrator can give the award as per that change in land use. If
Sir,
that has not been followed, then it cannot be done.
Sir, another submission is, sir, in respect of certain cases, actually the period of 90 days is already lapsed.
Yes.
1.5 years or so has already been lapsed.
Yes.
As per the Arbitration Act, we are not supposed to approach the court of law after 120 days from
Yes.
the date of passing the arbitrator's award,
Yes.
sir.
Yes. Yes.
But what can we do with respect to the cases where that period has already been lapsed? And what action is really required for us, sir? That's what we request Your Honor to kindly tell us.
As you
guide
have
us.
correctly pointed out, there is a limitation period for challenging the arbitral award. It is 90 days plus maximum 120 days. It is there. So we should file an application stating that it is not within the limitation period.
Sir, the limitation period is already over, sir.
Yes, yes.
Can we become a silent spectator even
No,
if
no,
we...
no, no.
Ah, sir.
There are rulings of Supreme Court also on limitation period also. We have already filed some, there is a stay by Supreme Court on these cases also. So we have to properly defend the cases on this ground that limitation period is there. But parallelly there is another issue also. Okay, that is okay that we should file and just, but if there is some merit, because we have to make the highway also, just challenging and without doing anything. So that has another side also. No? Suppose if we agree, okay, suppose this is, they have filed but amount is small, then we can agree and this case. So just without any challenge on your basic thing, the
Sir,
core area,
Sir.
core subject on that, we should see that also.
Sir, can you really guide us? What is the actual forum which we have to approach in such case?
No, Appropriate forum is your DJ only. The arbitral award must have been challenged in DJ only.
Thank you so much, sir. And even the period of limitation is already lapsed. We should make an effort.
Yes, yes. No, no.
Even in some cases, I have gone to the High Court also for giving some direction to the district court because district court had dismissed our petition that was beyond 120 days. It is the law of the land. You have to follow the law of land. Why you are not submitting your appeal within 90 days? Even don't think of 120 days. It is 90 days only. That is the discretion of the court.
Sir, sir.
So please, I request all my actions and PDs, please be...
That's why timely monitoring and timely action is also. In many times we also go
Yes, yes.
after 90 days. So that is the issue. So it is a purely monitoring issue where whenever we receive, and if the landowner is going to court after the limitation period is over, we should immediately file on this ground and get it quest.
As a division head, as a project unit head, all PDs and action have to be careful in this. Please don't be dependent on your subordinates. I am not saying your subordinates are not good, but you have to also monitor all these cases. Generally what is happening, I have also seen, I have also faced almost 10 or 12 cases that was not entertained by the district court. We have gone to the High Court also, again not entertained. Finally, I have to agree to the awards given by the Kala arbitrator.
Sir, thank you so much, sir.
Bimalji, one more issue, what he raised actually. Suppose if Kala has taken nature of land as agricultural land,
yes.
but in fact it was abutting to NH land. So Kala will not revise its award. So as a agreed party, NHI has gone to the arbitrator. So we will have a plea because our farmers have gone to the arbitrator. Then they will say it is abutting to NH land.
No.
That
Whatever,
was well before 3A notification.
Yes, no
but
issue.
Kala has erred in giving its award. So that can be corrected by arbitrator.
Yes, yes, no issue on that. If that is clearly defined that these lands, their market value is this, then circle rate is to be followed is this, then arbitrator can give, no issue and all.
Yes.
Here, no question of change in land use is not there, na?
He was saying abutting to NH land.
No.
So
In that
if it was...
case, if it is proved that it is abutting the land, as per revenue record also, these are the circle rate to be applied
Yes,
for that,
yes.
then arbitrator can give the award, no issue on that.
Then they can give another award, means overriding
Yes, sir,
the Kala's
arbitrator
award.
can announce it.
Modification or a change of the award, basically, then he can pass the arbitration order saying that the land use was not wrongly mentioned in the award and I am giving the land use after getting all the required documents.
No issue. That is, no. There the land use change is not there. But the land was abutting a national highway. So there is a different rate for the national land abutting highway. Land use remains the same, but the rate is
Land use,
different. Huh?
yes.
So that rate, what was to be applied, has not been applied by Kala.
As agriculture land. Later, the landowner goes to the arbitrator. I have converted this land, though he has not converted physically on the land. He goes to with the order that I have converted, but I have given only agriculture and I am eligible for the non-agriculture rate. So the arbitrators are revising it and giving non-agriculture.
If it is recorded,
Moreover, I am supplementing his question. He has deposited the land use charge also, but competent authority has not given the order. So there was some order in the state government that if it is not converted within such and such period, means maybe 60 days or 90 days, then it will be termed as or considered as deemed conversion.
Yes.
So many people are coming with this plea. So it is already deemed converted.
yes.
So what is your opinion on this?
No, but that is very clear. If the concerned landowner has deposited the dues and has applied for that, and if there is no objection on that, and if it is not denied, then he is entitled for that. No issue on that. Whether it is the order has been issued or not, there is no issue in that.
I'll
But
just,
if there is some conditions are there.
I'll just supplement to your points. See, changing land total state subject. Okay, there is a procedure. Once I have applied for a change of land use, I have to pay certain fees. Once I have paid certain fees, there is a committee which will be going and checking that thing. By changing that land use, whether others are getting affected or not. Only after that, then the authority in the state, they will allow him to change that land use if there is a NOC, no objection from nearby people. So in that case, suppose I have just paid the fees, but that NOC has not yet been obtained. That it's just by paying the fees, you have not changed your land use. It's once the approval by the land authority, the state government authority has been given, after due verification of that area, okay, this is approved. The land use change is approved. Then it will be considered. If that thing he can produce in front of the arbitrator, if Kala has given him agriculture land, but if he can produce that my land use change was approved, so this is the document. At that point of time, arbitrator can give the that land use change applicable to him and give the award of that residential or commercial, whatever he has given.
What is my fault as a
No,
farmer?
no, because they will be taking time. There are some time limits. It is every state government has certain time limits. That 40 days, 45 days. Within 45 days, that verification has to be done, and after that, the NOC has to be obtained. Then only the approval of that land use change can be given. So, if those things have not been followed, it cannot be taken as that land use change has been carried out.
One issue is that the land use, there are two GOs in state government. One GO is 98 says, once you paid the fees in the Me Seva, that is a E-Seva center, that is deemed to be converted.
If that is the state, again I told you, it is a state government subject, total state government. What is their ruling says. And if as per that ruling it is says, if once the payment has been done, land use has been changed, it differs from state to state. I am talking about like my state in Odisha, till the time the inspection is not carried out, and he obtains a NOC from the nearby area people that by converting this into residential, his land is not getting affected, or by his approach is not getting affected, then only he will approve that land use change. So in such cases, it again differs from state to state. If you are saying your state has got that, by depositing just the money, the land use change, if there is an authority, that authority can be produced to the arbitrator, and the arbitrator can change his award. Okay. Changing the land use.
That earlier GO has been superseded, now new GO has come.
I told you this is what
whatever is the policy of state government, if they certify that it has deemed to be change in land use, then you have to give, otherwise you can.
Excuse me, sir. Another issue, sir. Of course, he has paid the requisite fees for conversion of land, sir.
Yes.
But physically, it was not converted, sir. The land was
How it is physically
still
converted?
still is an agriculture land.
No,
but
you
he has
tell
not
me.
converted for
You
non-agriculture purpose. Sir.
You tell me how it is physically changed. Land remains the land only. If there is any condition precedent that you have to construct the residential house within 1 year, or you have to start the commercial establishment within 2 years, then it is a conditional change in land use. Suppose it was acquired within 6 months, then how he would have done that?
In the executive instructions itself, sir, there is a provision, a ruling of the Supreme Court. It was mentioned that he should actually change the land use physically also, sir.
No, how it will change, you tell me.
In
Na?
Annexure 3.3, sir.
No, I am not disputing. But you change, how physically you will change the land use?
And just by paying the simple amount, how it can be considered as non-agriculture land, sir?
No.
Or as a house site, sir?
It is change in revenue records by paying a due whatever state government has levied. It has changed. Unless there are some conditions imposed on that land use would be valid for 2 years only. If you have not started any commercial establishment or industrial, then it will deemed to be elapsed. Unless there are conditions.
There in Andhra Pradesh, there is condition is there.
That's why.
frequently the collector has to visit the site,
That's
whether
right,
it is
that's
using
right.
for the
If-
non-agricultural purpose or not. Automatically it will be denotified again into
Yes,
that.
yes. That's why I'm saying. Na, if state government has imposed some condition, but take the case where suppose just 1 month back he has got his converted. Now after 1 month you have acquired the land. How he will fulfill the condition?
No, what I am saying, sir, even at the time of Kala inquiry or at the time of award also, let them have the inspect the MRO,
No,
local
no, no,
MRO,
no, no,
and
no.
give a certificate stating that it was not converted. Even then, it was
No.
given.
No,
in
no,
one
no.
month.
I am giving you a condition where suppose in August some person has got it converted to non-agriculture or residential site. After 1 month, we do the acquisition. He was supposed to construct the house within 1 year. But after 1 month, we have got for the same land for acquisition. Then how he will construct the house within 1 month?
What I am saying, sir, even then, that was after 3A, 3D notification, everything after is coming for Kala.
Yes.
After Kala award also is going for arbitrator for enhancement.
Yes.
At that time also let them MRO give inspection certificate to the
What type?
arbitrator. Because it is still they are not using it for non-agriculture, using it for agriculture.
No, no,
After
I am
after
telling
3-4
you.
years, after 3-4 years.
I am telling you. Nah. Once the land has been acquired, they are not supposed to do any activity on that. After 1 month only you have gone for acquisition. How he will construct the house?
No, his question is that prior to 3A notification, before 2 years, it has been taken conversion.
That's why I am saying. No?
But he has not executed the non-conversion
That
purpose.
is clear.
Then whether
I am not disputing on these cases. If sufficient time has passed before 3 capital A, then he is liable that he will not get. If the condition time is over before 3 capital A. But I am telling you the condition where 3 capital A time has not passed the condition time.
No,
In what? In
even
that
after
case,
3
what
years-
will you do?
Sir, exactly. What he is saying, see, today you have got the order from the state government. Okay, you are allowed to convert. Okay, with a conditionality, within 2 years you are supposed to construct your house. Okay, after 5 days, I come, suppose you are a landowner. I come and I say I am acquiring your land. Okay, here I publish my 3-year notification. Hereafter, you are a person non grata. You can't do anything on this land. Okay, the moment I have published my 3-year notification, you are not supposed to do anything on that land. How will you construct a house? Getting my point? So, automatically, you are within that conditionality, you are there. Within 2 years, you could have constructed if you were allowed to enter that land. Because you are not being allowed to enter that land, you cannot. So, arbitrator will see all these things and he will say, no, he is supposed to be getting the amount for his residential area. This is what.
One, sir. Regarding, I will say the one example. The land conversion was done in the year 2007 or 2008. The land was acquired by us in the 2018. But they have not using it for
No. In these cases, automatically we agree.
In that case, if you have not changed the land use, that cannot be converted. So it will get for agriculture only.
That even then the arbitrator.
That is wrong.
The arbitrator is wrong. You have to fight it out. Our legal experts whom you will be employing, they have to fight it out like that.
Even
that is wrong.
Kala has given an under agriculture
Then
land.
arbitrator.
But arbitrator is
Wrong.
Any provision for not cancellation of the proceedings issued once he has not done the as expected by the order. But they said it is only the collector should list it out and send to the government. They have not given any clear in the act that it should be automatically cancelled or not will be cancelled by the authority.
No issue. But if there is any condition precedent which was imposed on conversion order, it has to be followed.
And one thing, sir,
Whether it is converted or not, but some condition precedent for conversion, it has to be followed. Then only he will get the enhanced market value based on conversion.
And another question, sir, clarification regarding 34 is concerned.
Yes.
Before the district judges, they are having limited powers.
Yes.
As per the act is concerned.
Yes, yes.
But they are going as per the decisions of the different courts.
Yes.
And now they are passing the orders. Supreme judgment of Gayatri Balaswamy there, 5 benches, 4 of the held. The limited period has not paid by the lower courts. Basing on these 4 bench and 5 bench,
No,
they are,
there is
they
a
give it.
judgment where the award can be bifurcated in 2 parts. Severance of award is possible.
No, no, here it clearly said, sir, though this was a departure from previous interpretation, the majority ruled that courts can modify an award in limited circumstances. But even what limited, they themselves taking law into their own hands under the guise of this judgment, they are enhancing.
No, limited.
The district judges are enhancing the amounts.
There are some
Either they previously, as per the act is concerned.
without giving effect to this also, they are changing, DJs are changing it. So we have to contest in next court. There is
Now they are taking this
nothing
as one
you
of the
cannot
case.
do.
You understand in our how judiciary activism is going on in India.
Yeah. That
So,
is there, sir. That is there.
But we can't question those things. All of us know it. There are certain judges, they are going beyond their power. And there we have to fight it. We have to fight it out in the higher courts. That's all. You can't do anything.
Only solution is that we have to
Under
fight in
the-
next legal forum.
Our district judges are taking only one main point is, sir, under the guise of vicinity. Taking into vicinity, they are passing their own award, enhancing
No,
the
no,
amount.
vicinity.
Where is the vicinity? There is
If
no-
you go by vicinity, then you will reach Vijayawada or you will reach Delhi.
Yet there is no vicinity means it within 500
Suppose
meters of
I will give you an example. This village is nearer to another village. This village is nearer to some city. Then automatically you take the multiplication factor also. Everything will change.
No, vicinity means they have not given what is the vicinity within 100
No,
meters or
vicinity
500
is
meters means
simple,
it is not
logical.
there.
There is no question of 500 meter, 200 meter. Vicinity generally is same village, same type of land. Unless there is something which is neither the sale deed available nor the circle rate or guideline value is available, then only you can go vicinity. Then also you have to see whether similar type of land is there, similar potential is there.
No, under the guise of this vicinity.
No, they must be doing anything. But we have to challenge on these grounds only. Na? Vicinity cannot be just, you take a case of Delhi. Suppose some village is nearby Delhi, we take that this is vicinity is Delhi only, you give us the rate. That cannot be taken.
No, district judges are
There
taking
should
advantage of
be-
this vicinity and passing the awards.
Oh,
And enhancing,
some-
modifying the awards.
We have seen,
Yes,
we have to see as per the totality of that case. We have seen many awards where they have given exorbitant high rate without any reasoning.
yes.
10 times, 15 times they have given the rate without any reasoning. Yes, yes.
This we are following it and then we are
It
implementing
has
it.
to be. It has to be.
Sir, there are 3 points.
Yes.
First one with respect to the time frame for arbitration.
Yes.
So if you see the 29A1, so
Yeah.
it fixes a time frame of 12 months from the date of completion
Yes,
of proceedings.
yes, yes, sir.
But there are many cases that are pending even after 2 years. So what is the fate of those cases even if the collector or arbitrator passes the award?
You are telling me 2 years. I have seen the cases where after 10 years the arbitrator has passed the award.
What is the fate of them?
That's because we have not countered, we have not defended the case properly. We have also slept. Generally, executing agency has not filed any application before the arbitrator. We have not done our work also. We have to immediately, just like in 90 days case also, we have to file the application for disposal. Similarly, we have to file an application before the arbitrator or before the DJ to get the arbitrator dispose of these cases or dispose of them ex parte.
That's the first one. Second one, even in our manual at page number 148, we have a proposal to appoint non-collector arbitrators, who are senior retired IAS officers.
That is different issue.
Okay. And the third one, sir, the last point we have mentioned that taking videography
Yes.
of the pictures. So as per our manual, a DPR consultant will take the videography. So the taken videography is not supplied to Kalas. And while evaluating
No, I will tell you. Recently, we have issued a circular where just before 3 capital A, videography through drone video has to be done. That would be available on Bhoomi Rashi most probably only, and a detailed JMS report has to be filled, and which will be available on Bhoomi Rashi. So when Kala is deciding the structure award, that would be available to him to verify.
Yes.
So we have already made the provision that will be there.
Yes, sir. In the map.
Yes. Yes. Yes.
So that all the assets will be geotagged.
Yes.
It cannot be altered or it cannot be any
Yes.
malpractice.
Not just that, just before 3 capital A, separate instructions are there to get the drone videography just before 3 capital A, so that we can know the status of the structures, etc. So that later on there is no dispute on that.
Thank you, sir.
Yes.
Sir, small submission.
Yes.
Sir. You told that before 3 capital A, sir.
Yes.
Before 3 capital A, we do not have any right to enter into the property.
We are not entering. We are just flying the drone to get the feel of that structure, ROW things. We will not enter into his lands. We'll just fly the drone and take a aerial view of that.
Flying drone is also a legal issue, sir. We have to take permissions from the.
We have empaneled the agencies which will take the care of all the permissions and before flying that. Already we are doing that.
Sir, you are telling that there is a limitation for filing of arbitration petitions before the district court for a period of 3 years.
90 days. District court, it is before arbitrator. Yeah. Yes.
Where is it? Where is it?
In Arbitration Conciliation Act, there is a mentioned in NH Act that provisions of Arbitration Conciliation Act will apply to all arbitrations under NH Act also.
That is one thing. You are saying
Yes.
that Limitation Act. It is not there in the Limitation Act.
Which-
Nor
Sir,
it is not there in our act also.
Easy reconnect. Okay. If you have seen that 3G 6 or 7 of there, he is connecting it to the Arbitration Act. Okay, Arbitration Act, this all arbitration will be applicable as per the Arbitration Act. When now you enter into the Arbitration Act, in Arbitration Act it is says that all arbitration will be governed as per the Limitation Act. So that Limitation Act is 3 years. Okay, so that's why this 3 year has been given in that.
Some arbitrators, they are allowing that petitions also after 4 years, 5 years.
We have to
After
contest
4 years, 5 years also, some
they are
arbitrators,
allowing,
collectors,
we have to contest that, that they cannot
simply
entertain the.
they are passing the awards. They are allowed
We have
the
to contest the
petitions.
next
There is no-
higher court.
There is no limitation petition. Simply they file a letters before the collector. They allow that
That's
petition
why-
and
that's
give
why
notices.
These workshops are conducted basically to educate the arbitrator also what are the legal provisions. So that is their what process they have to follow, because all are government officers. They have to follow some rule or some law. So that's why these workshops are being conducted to capacity building of that arbitrator, college, everybody.
Another thing is one district, regarding to conversion.
Yes.
The RDOs give the permissions, conversions to the land before 3 years, 4 years, 5 years.
Yes.
The Kala consider that land is agricultural land, even
Yes.
after conversion also.
Yes.
As there is no development activities.
Yes.
So, but before when the matters come to the arbitrator, the arbitrator allowed that petitions.
Yes.
They treated it house sites and other commercial sites.
Yes.
So it is burden to the NSA. There is
No,
even
no,
there
that
is no
is wrong.
development.
That's why
One
we are
thing,
telling.
another
Yes.
thing is the land was not converted, but
Yes.
layouts were sold away.
Yes.
Superior basis, the sites were registered.
Yes.
Even that also, the Kala treated that land as agricultural land.
Yes.
Before coming to the arbitrator considered that as house sites.
No.
So
both are
that is
wrong.
what is going on in the one or two districts. Some arbitrators.
Both are wrong as per Act,
Yes,
unless
it
that
is wrong. It is
yes,
wrong.
yes, it is wrong. You have
It
to
is wrong.
contest it.
But we can take the steps in that aspects.
Only we can challenge it then, because if arbitrator has given any award, we cannot say anything on that. We have to challenge it in DJ only. That award has been passed without any justification or not following the rules.
Before, when the matter is filing district courts,
Yes.
there is a Supreme Court decision. The court cannot have limited powers. It
No,
refer
they
in
can
the
quash the award,
arbitration.
na.
So some courts they are referring the matters to again to the arbitrator.
No, they can remand back. There is no issue on remanding back, but they cannot modify the award.
Yeah. So we have to take the consideration as house rights.
No, then you have to challenge again.
Again, we have to go to High Court.
No option on that. Na? If some legal forum is giving a decision, you have to challenge it next court only. That is their jurisdiction, they can do.
Sir,
Yes.
after the discussion, I have got only one or 2 points. Sir.
Yes.
Number one is with reference to the conversion of the land as rightly pointed out by our learned senior officer, sir.
Yes.
The thing is, in a particular district, I am
Yes.
not naming it, sir.
Yes.
What happened? It has come to my notice that 15 people,
Yes.
actually they got the information that the road is going to be formed, and
Yes.
they filed
Yes.
8 or 10 petitions for conversion of the lands in advance.
Yes.
They are very intelligent, sir. Here
Yes,
in this
yes,
particular area, actually,
Yes.
the people are very, very intelligent.
Yes.
And they filed a petition, they filed an application before the
Yes.
concerned authority in
Yes.
respect of 10 lands which are going to be acquired
Yes.
by the project at a future date, sir.
Yes.
In such a case,
Yes.
what to do, sir? Almost all people they have done like that. That is one point, sir.
Yes.
And the second thing is, sir, a particular arbitrator,
Yes.
he entirely changed the award of the Kala, sir. Actually, there are 12 awardees, sir. He modified all the 12 awards. He changed the land into land abutting national highway category. Okay, because the Kala has not at all seen anything like
Yes.
that. He has given such an order. Can we consider that, sir? And in that particular case, sir, what happened? Can we consider the road which we are forming,
Yes.
and that road work is still not completed? It has not been commissioned so far.
Yes.
But still, the arbitrator has considered it as a land abutting the highway. Can we accept it, sir? Because the time is lapsed, how can we accept, sir? Entirely, certain arbitrators, they are really making use of their powers in such a manner,
There
sir.
are two issues you
That's
have
the
highlighted,
problem,
na?
sir.
One is change in land use, where they have get the land use applications filed just before 3 capital A. In that case, you have to prove the malified intention. Okay, within suppose 1 month back only they are filing the application, and within so short time they cannot construct any award. So that's why you have to prove that their intention was malified, and it cannot be.
Oh, that can be discarded, sir. That power is really
there is
there.
a direction. Alignment is approved, then they should not be changed. We have issued that direction, but as far as law goes, we cannot. So that's why there comes the issue of malified intention. Then you have to prove that intention was malified. So you have to, secondly, where it is a fact that if it was abutting national highway, if NH was not there, then they cannot get the benefit.
Sir, my point is, sir, as rightly pointed out by Honorable Sir, what happened, sir? The Kala's award cannot be modified under the Arbitration Act by the arbitrator. That's what we were said a few minutes back, sir. And right, what is happening? They are entirely changing the category of the land, sir. Category of the land.
Arbitrator can modify. They cannot change the category.
Yes, sir. That's what.
They can modify, but
Very
there
good.
are
We are very thankful, sir.
There are some issues, just like of if NH was not there, they cannot claim that it was the abutting national highway. But if it is 4 laning, 2 laning, In these cases, they can get. Change.
Are you talking about a green highway or a brownfield?
Sir, that's why I would like to submit, sir, because of the time and all that I did not mention, sir. So there are two categories of highways. Number one is brownfield highway and the second is greenfield highway.
Whatever you discussed now,
No, sir.
are
No,
you
sir.
talking about greenfield highway
Yes,
abutting
sir,
land
it's a
or
greenfield highway, sir. Actually, it is a bypass road, sir. For
Okay.
the national highway, it is a bypass road.
Okay, but I understood your question. Okay,
Yes, yes,
tell
sir, that's the problem,
If it is a greenfield highway, then there is no question of abutting a highway.
Yes,
so
sir.
that is what whosoever your that legal representative, he has to fight out in the court that how come it becomes a abutting a highway when there is no highway because we are constructing a greenfield highway.
Sir.
That's a simple. I don't know why we are dragging
no, sir.
this thing.
That was done, sir. Written orders are really there, sir.
That's wrong. But if it is, I understand. I told you now there is a judicial activism is there in our country. So there are certain judges, they are passing orders without applying their mind. There you have to go to the higher authority and higher court, and there you tell your problem. This is what they have not applied this mind. So this is the correct this explanation. You might get a relief, you may not. So you have to live with it. Then you have got another. You can go up to Supreme Court.
Yes, sir.
And then once Supreme Court gives a order, after that you just have to obey and move forward.
Thank you so much, sir. We have been cleared, sir, in this respect. But
Thank
I would
you.
like to
Thank you.
submit the fact is, sir. I would like to submit the fact for kind notice. Sir.
You're a advocate or?
No, sir. I am LAO, sir. I am working in
we are
executive engineer.
We are
Vijayawada, sir. Vijayawada office. I am working, sir.
Okay,
and
right.
we have been striving. We
are
both are fighting like anything.
You are telling
And
that.
because of the problem that is created from the arbitrator, actually we are differing in respect.
So I have clearly told you there is a that upscaling your ladder, go up to Supreme Court. Nobody stops you till the time you prove your point. If you can't prove, Supreme Court also says no, the arbitrator is correct. Then you have to obey and just move ahead. That's all.
Sir, actually the ROs are pointed out in a particular case. I don't want to mention the specific case, sir. Actually, in that case, there are 12 arbitration cases. In respect of one arbitration case, actually what happened, the arbitration category, sir, 1.5 year period was already lapsed because of one reason. Actually, they sought a clarification. The RO is very kind enough. He has given a specific direction to the subordinate officers that there are other 11 cases. This one case is totally linked to those 11 cases. You should be very carefully act in this respect. Like that, the RO has guide, warn the officers.
Obviously, he is concerned. If
Sir,
this
kindly-
case is lost, then other 11 cases also
sir,
will be lost.
I will keep quiet, sir. I don't want to talk anymore further, sir. And what happened? They addressed the Solicitor General for an opinion, sir. It's very difficult. If we want to address the Solicitor General, either the RO or a senior most officer only has to address. Solicitor General is not, he usually he will not answer the lower officer, sir. But for that cause only that matter has been delayed for another year. Now 18 months have been passed, sir.
Okay, doesn't
And
matter. You are talking about him. He told you there are cases for 10 years. After 10 years also the arbitration is going on.
Yes, sir.
So
my
you just do your duty and keep scaling it up. And you have to fight it out till the time you get either favorable judgment or unfavorable, whatever may be. The final judgment has to come.
Absolutely, sir. Thank you so much.
Thank
sir.
you. Thank you.
Yes.
I will say the example you are saying it, the district judges have no power to modify the award.
Yes, yes.
It is there as per the act.
Yes.
But they are going beyond the section, and as per the Supreme Court judgments, taking advantage of it, they are passing, sir. I'll tell you one example. He want to enhance the amount without any documentary proof. So he has written in the judgment, the lands in which acquired lands of the parties are very nearer to Krishnapatnam port.
Yes.
That's okay. At least we can believe it is vicinity he had taken. And also, it is very nearer to international airport. There is no airport in Nellore, sir. That is the way, what we have to do. They want to do the justice to them or to us.
No, we are awarded the announcement.
No, in that way they are going into deeper.
No, without any justification.
Yes.
At least here he has written something. But we have seen just to award the rate from 25 to 2000. We have seen this type of
justification not there, okay, sir. But regarding justification is concerned, there is international airport. There is no airport at all. Where is nearest vicinity of international airport?
You are correct. But then we have no option but to challenge it in
We
next
have to
forum
challenge.
only,
We have to
na?
challenge. And they are enhancing up to 100%, sir. 9 lakhs was given by the arbitrator.
We are having cases where it is announced 1000%, not just 100%.
District courts, what I am saying is district courts.
Arbitrators.
No, I am saying about district courts are
District
not
court also.
Yes.
District court also. So we have every type of cases where any amount has been announced by arbitrator or DJ.
And regarding cases
Like in one point, I must tell you that we are not defending properly. One of the reasons for these type of judgments is this.
Sir, even if it
I have seen the petitions where the main ground was never defended.
No, sir, because we are thinking it as for 34 is concerned, their powers are limited. Whether they have to admit it or reject it. But there are no modification.
No,
there
that's
are powers.
okay. I am not saying it. We have to contest it further. But in defense, what defense we have taken, we have not taken the grounds for defense also.
And one thing, sir, you are saying it, we have to file a petition for the old cases because it is now in Nellore, some of the cases are land was acquired in the 2018. And now 2022 land was acquired. 23 land was acquired. Separate similar packages.
Yes.
Now they are taking the cases of 2023, but they have not given notices for the 2018. We are losing. That we can't file a petition, sir.
Yeah.
They have to issue notices. You have to give notices to the collectors. At least let them dispose the old cases first to avoid the interest.
No,
because we can't file a petition, sir. They themselves as RDO.
Why? Why we cannot file it?
How we are going to file a petition? Because it is filed by the petitioner. Aggrieved party filed a petitioner.
If someone has filed a petition with arbitrator in 18, and if arbitrator is not deciding the petition, we can always file a petition for early hearing or dispose of ex party.
Who has to file, sir?
We can file. NHI can file because NHI is other party. Who is stopping you to file?
No, till the date, no, they say.
No. We are other party. If arbitrator is not deciding, we have to file an application that you decide ex party if they are not coming forward.
No, the thing is, once it is come to from Kala, comes to the arbitrator. Arbitrator has to give the case number and they have to issue notices to both the parties. Now they are not given the number. Then where is the question of giving it?
Now then suppose in tomorrow they are getting it number, then you fight it that it is over, limitation period is over.
The party has given already earlier within time they have given the notice. These people are not giving number. They have already given it time.
Issued, you can always find an application to either dispose of ex party. There is no stopping you. You put it on record.
No, sir. What I'm saying, the arbitrator
That's why
case
I'm telling
number.
you.
He has to give case number without expert.
One of the reasons is that we are also keeping mum.
No, sir. What I'm saying is, if he has given a number, case number, then if other people,
No,
person is
how
not
do
coming.
you know? If you have any knowledge, they have issued some notice that this so and so case is filed. On notice also you can file an application that.
No, we have to take notice from a list from the Kala, whatever this road pending cases, let them give notices to both the party. Arbitrators give case numbers. Without case number, we can't give notice. Even if I can't file a petition.
Then
Kala, the arbitrator has to give case number. Then only I can give now. Now they are
how
giving.
they have issued the notice?
And they are not issued notices.
So
till the date.
then there is no application of arbitration.
No, sir, the cases are there. They are not giving it.
How you are saying? How it is identified?
But now they are giving it. Now,
Then you just file that it is beyond limitation period. Close it.
No, no, sir. Within limitation, the aggrieved parties already given notice, filed the appeal before the arbitrator. Arbitrator has not numbered the cases. They have not issued till the date to both the parties, the NH or to the aggrieved party. Now 2023 the cases that they are giving, 2018 are still with them.
Just you file a defense that it is over, limitation period is over. Now it is not accepted.
They have given in time now, sir. It is what is the party agreed fault and part of the party. Party has given in time, within time.
Once it is filed in time, then you have to, if the arbitrator has not decided, then you say that your period of 1 year is over. There is a period of 1 year for arbitrator to decide the case.
When he has not giving the number, it counts only with the given
Tell me, how do you know that application has been given to the arbitrator? It might happen. It might happen. Recently, I had received a case file. Somebody alleging that such and such Kala is not forwarding the applications written by landowner to the arbitrator because he is asking for money. Okay. These are the things also happening. So I, as a landowner, I go to Kala. I say, I want to go for arbitration and please forward my application to arbitrator. Okay, I have given. But Kala is sitting on that application. So how do you come to know whether it has that application has gone to the arbitrator or not?
No, sir. They think here, 10 cases are gone to the arbitrator.
10 cases.
2018 example, sir. Out of 10, 6 cases are disposed. Other people are saying we are also sent on the same date. We are not yet received the notices. Our case are not disposed.
That exactly I am telling. That Kala might be holding it back.
No, they have already sent to the...
How do you know already sent to you?
No, party is saying they have sent to the arbitrator, sir.
Who saying? Kala saying. If Kala is saying, that is the proof with you. You take it from Kala that such and such people have gone to the arbitrator on such and such date. So on that basis, you write to the arbitrator, this is what Kala says. They have submitted an application on such and such date, and till now you have not discussed. There you can establish your thing that you know that application has been submitted to arbitrator. Somewhere it has to be established that application has reached the arbitrator. In this case, which I am saying, which has come to my notice, they say the allegation is on Kala. Allegation is Kala that he is asking for each application, he is asking 5,000 rupees to send that application to arbitrator. So then we wanted to check it. Whether it's a pseudonymous complaint, anonymous complaint, but that also you don't know. So whether these people figure in that award or not, 3G award, if they are correct people, their name also must be there in the award. The 3G estimate which must have been paid. If it is there, then there must be some certainty that yes, these people are saying. If their name is not there, then it will be treated as a total pseudonymous. Somebody else is writing just to malign the Kala. So those are the issues. You have to establish how that letter has gone to the arbitrator. And after that, you will take action.
Kala has sent all the letters, out of which only 5 or 6 cases are...
Out here, this is directly filing.
As per Act only, they have to file the application before arbitrator.
Within 3 years.
Okay.
In RFCT, there is a provision they can file with the collector and he has to refer the matter to reference. But in NH Act, they have to file the application before arbitrator itself. They cannot file before the Kala. Plus, whatever notice, come to our notice, we can always file an application before the arbitrator. The issue is we are not monitoring. We are just saying Kala has not issued or arbitrator has not given number. We can always file an application with the arbitrator. This is the landowners are doing. They are asking for it. Whether you have taken cognizance of that or not, you tell us.
No, what I am saying, sir, that the arbitrators are now disposing the cases pertaining to 2022, 2023. But why can't they take into consideration the 2018 pending with them?
That's why I am telling you, no. That is their discretion. We have to defend.
Discretion. We are losing interest. Ultimately, we are losing interest. All these years, we have to pay interest.
Let me. That's why we are saying when we are defending the case, we have to put our points clearly that it was filed in 18. You have lost your right. Within 1 year it was to be decided. You have not decided. You have lost your right. We have to take the defense of these things, whatever legally is available to us.
We can take the defense whether
We
he
don't
is
take.
without,
We don't take. We don't take. I have
without-
seen.
No, without what I'm saying, if it is not filed within 3 years, okay.
No.
Now it is filed in time.
It was
They
not
are
decided. If it is not decided within 1 year, we can also take that plea also, that you have lost your right.
Sir, is it supported?
This is, we are saying,
There are only guidelines. Sir.
Provision of Arbitration Conciliation Act applies. In there is a provision that it has to be decided within 12 months. So that applies there.
But nobody is
Nobody, but
nobody is
because we are
disposing
not
within
taking
12 months.
defense also. We are not taking defense also.
Sir, even we can take defense also,
No.
they are not considering, sir. They are not considering.
Then it is their wisdom, then we have to challenge it district court.
Yes.
Then that may be the reason. Due to that 2018 it was challenged, but by this time we have already constructed the road, so we are also not bothered to get it disposed at the earlier.
That's why I'm telling you.
District collector also not taking care.
There are
This is what happening exactly.
many issues at our end also. We just bothered when we get the land, we are not bothered. Whether arbitration is filed, it is decided or not. Generally, there are cases which are pending because we have constructed the road, we have taken the possession of land, now it is going on. You tell me the case where we have filed a petition immediately after the limitation period is over. We have not filed.
Excuse me, sir.
Yes.
Excuse me, sir.
We want to make through you to all the advocates now. Then they can file in all the cases which have
all legal remedies are available. We should file our defenses properly, taking recourse to these legal remedies. 3 years limitation period for filing of arbitration. Arbitrator has to decide within 1 year. Then we have to also file proactively. In many cases, we also don't file our defense within 1 year.
Excuse me,
it
sir.
is both ways. Yes.
Sir, I have a doubt, sir.
Yes.
Sir, in recent past, we are facing one issue, sir. Wherever cases we have filed before DJ court.
Yes.
So, DJ court is entertaining the EP. So, execution petition of the petitioners, and they are creating freezing of Kala account, or giving the order to take away all the PIO office equipment. So, in such cases, sir, and surprisingly, the same case is pending in the same court.
Legal remedies available are to get the stay on that arbitral award, or we have to
No, it is taking time to decide, sir. Meanwhile, these people are coming and
no legal remedies.
Sir, in one case, PD Garmi District, they have said PD is not responsible. They now you go against the Kala, not the PD. Then the court going to be stopped. Now they are not going to execute the EPs because they cannot directly go against the PD. They should go against the Kala. They are wrongly filing.
No, sir. Here the case is PD has filed an appeal on the arbitrator award, sir.
Of course, EP, in EP, if they go for it, EP should be against the concerned authority Kala, not against the PD. PD is not at all authority. PD is only not a statutory authority. PD is only recusation authority. Then the statutory authority is Kala. They are supposed to go against the Kala. So if you put that version, and they put the version in the court, then that court agreed that. Now all those EPs which were filed, they have been stopped now. No more execution for them. So the same thing you can use also.
That order is there.
Yes. In Vijayawada is there, I will send across.
Sir, one more question, sir. Suppose we have challenged a Kala award before arbitrator, citing some grounds, and arbitrator has upheld that award, Kala's award. And then if on the same award, if the people, landowners again go, Can the arbitrator decide while already he has upheld the Kala award, sir?
This is the
Is it
different.
bar? Is it barred like that, or landowners can separately go?
They have right. They have right, and it will not come under the. Once he has given one thing, and the owners have filed their version. Once he has given the order, it will not. They have the every right to go to the arbitrator. You cannot decide that once I given in favor of NHA, I cannot entertain your application. No, you have to entertain. Arbitrator has to entertain and pass the orders.
So he can entertain once he has upheld, and still he can change that up.
Yes.
No, but at the time of upholding also, the other one is respondents is landowners. Respondents are landowners. District court or arbitrator, whatever they have upheld the case, then he cannot go again for the arbitrator. Instead, he has to go for DJ court.
Sir,
NHA has gone, and the arbitrator has not given any notice to the party. So, in the absence of arbitrator party, he has given an order. Then the party has every right to go to the arbitrator for his the right.
That is again where. Hello. Okay, here again comes to the legality, and it is very clear. Once a arbitral award has been given, whether it is he has upheld the verdict of Kala, award of Kala, or he has changed the. After that, he cannot modify at his level. It is if the landowner is aggrieved, he can go to the higher court. But arbitrator, he cannot file a case again with the arbitrator and get it changed. That is very clear.
Yes, sir. In this case, the party was not heard. Party was not given an opportunity to file. In the absence of party, he has decided. That means the party has the right.
Then
to go.
what the DJ will the legality. He will find the legality of this arbitrator that he has not been heard. In arbitration case, it's both the party needs to be heard. They have to submit their evidences. This is my, the applicant submits his evidences, respondent submits his evidences. On the basis of that only, he will take a decision. Suppose he has not taken the evidence of one side and he has given a award, that means it's a faulty award which is here. On that faulty award, they can go to the higher court and automatically that will get quashed because he has not heard the evidence of the other party. So that is simple.
Helpful. A review petition before the arbitrator itself will be helpful because they have not been heard by the arbitrator. Instead of going to
the EP petitions were dismissed. In another court, they have given the attachment orders. That is going on. One thing. Another thing is we have taken that plea that the NHA has no way concerned. The land was acquired by the state government and the amount was given by the state government only. Then that aspect the judge has understand and dismiss the petition.
Let me clarify.
Another is
First thing. Execution petition, whether it is filed against NHI or Kala, that will be filed and they can attach the property of Kala also as well as PD also, because PD has to ultimately pay the amount. Kala will file like, okay, I am ready. If PD has to provide me money as per
taken any steps against Kala.
Kala is taking that stance.
Against PD.
Kala is taking that stance.
Kala is taking it. Amount in Kala account, which is paid by NHA only.
Yes.
So it cannot attach the state government award.
case, you are saying that the court has no power. In this also, the court has no power.
Yes, yes,
They are dismissing our
Yes.
AOP petitions also.
They will,
That is the situation.
they will dismiss.
Even
Because law applies for both, huh? Not just that law applies for landowner only. There are two issues. One is executing petition. It is clear that they can file against Kala, whether it is Kala or PD, they can attach the amount. Regarding that ex parte decisions where Kala or arbitrator has not heard the landowner, they have to file the petition in DJ court to get it dismissed. There is no provision for review petition. They have to get the award dismissed through DJ court only, and they can remand back to arbitrator to hear a fresh along with the defense of your landowners.
Regarding execution petition, sir,
Yes.
as per after the Amendment Act is concerned,
Yes.
Arbitration Act.
Yes.
Previously, once your appeal is pending before the district court,
Yes.
it is deemed that the stay is there. But after amendment is concerned, 2015 Amendment Act, you have to obtain stay.
Yes.
Unless until then they can have every
Yes,
right to
yes.
attach their property.
Yes,
what that may
yes,
be.
yes.
What we are saying, thinking we are doing is, along with the appeal, we are filing the stay petition.
Yes, yes.
But they are not granting the stay. They are issuing notice to other party. Why we are filing is, if they are going to file a EP, we can say stay petition is already pending. What I am saying is all of the other people also file stay petitions in the court, whether
Yes,
they are
sir.
going to grant
That's
stay
why
or
I am
not.
telling you, we have to file proper petitions for everything. If they are not considering our stay application, then we have to go to High Court to issue direction to DJ to first decide the stay application.
No, even after filing also immediately we can say, we can decide the stay petition is pending.
Yes, no, that's
That's
why
why what I am
once
saying
if
is, along with the appeal,
if execution petitions are filed, we have to immediately file a stay petition. If it is already filed, we have to move the High Court to get the stay petition decided.
sir, after all these courts they are not going deeper into the subject, as you said,
They are not going, but we are not defending properly also.
I will say one example, sir.
That is the issue.
The property is regarding the land was acquired for some other purpose, Telugunga project.
Yes.
In 1994.
Yes.
But that award amount, they have attached our amount,
Yes.
National Highways, under one decision stating that any amount can be attached. They have attached 25 crores nearly our Nellore amount.
They cannot attach the property of other agency.
No, what I am saying is that it is not no way connected with the NH. It is no way connected with the land acquisition of the roads. It was attached, it was taken for the Telugunga project in the year 1995. They got all these years, it is pending before the different high courts. And now they came over with the award. They are attaching our amounts readily.
Just check whether that land came in the land of NH.
No.
There may be. There are cases. Land was earlier acquired for some other purposes. Subsequently, it was transferred to NH. So they must be going for compensation for that part which is already used in NH. That's why there are.
R&B, sir. If these R&B roads are taken, we are taking off, then it will be transferred to NH.
Yes, that's why
This is not like that. What we have filed all the petitions before the court to raise the attachment because it is state government amount. You have to attach. Even as per the decision is concerned, it is only any amount with state government. Ours is a more under control of more. It is for the special purpose.
Not state government.
No, we are not state. That's why we have raised the attachment. All the cases we have attachment was raised for 25 crores.
We have to take up the matter with next court. But
No, in the same court we have raised the attachment, sir.
So you file an application, if you have wrongly attached, then it would be.
No, they are giving, sir, but once it is attached, very difficult to get it raised. But yeah, anyhow, within 6 months.
Somebody must have filed the details, huh?
Yeah, somebody might have filed the details.
Some advocate must have filed the details that you attach this thing.
No, advocate who is appearing on behalf of GP, Kala only has given the details, account number, otherwise who will give?
No, so why Kala is a party to that?
No, Kala is having only the number, account number. Who is going to know the account number, sir?
No, why Kala was a party to that when land was not acquired by Kala?
No, sir. Kala is same for that.
So that's why I am saying, some advocate must have given wrong details.
Even in one of the case, toll plaza account was booked against that arbitration award?
Yes, same sir. In this
Toll plaza.
Tirupati Toll Plaza account was
Yes,
attached.
yes.
Tirupati
Toll Plaza.
Tirupati Toll Plaza.
They must have given all the details of Kala accounts, whether it pertains to NH or somebody other thing. All the account related to that Kala must have been given.
All they have given, sir. Even for the purpose of Tirupati account, Nellore account, wherever they got the accounts, all they have attached. Under the guise, any government amount can be attached.
Any government account cannot be attached.
No, the decision is there, sir. Basing on the decision, they are obtaining the orders. Not is the way one High Court decision is there. Basing on that. But we have raised the attachments. Right? Very difficult, with great difficulty we have raised the attachments.
Wherever state government was supposed to give any amount to a particular landowner, there you can attach the any amount of account of state government. In NHI case also, there are some issues where they have attached not just your Kala account. They have attached the central account also. They have frozen that account also. So there are issues. Because once a authority is liable to pay anything, then all the accounts of that authority can be attached. It is not that only that particular account has to be attached. Because everybody knows they will not put anything in that account. So how they will ensure the payment? That's why they generally freeze all the accounts where there is a possibility to payment.
But we have stated that once you have already attached the property of Tirupati project PD, again you are not attaching the property of PD Nellore. It is not viable and it is not proper. In that way, I have filed a petition.
Suppose there is a demand of 5 to 10 crore. Suppose
it is there 8 crores. 8 crores demand.
8 crores. Suppose it is 8 crore demand. Your PD property is for 50 lakh only.
No. What I am saying is, well, he cannot attach going when there is a PD Tirupati is the proper party, sir. PD Tirupati is the proper party to the proceedings.
Yes.
You have attached. He got it absolute for 8.6 crores.
Yes.
Account was closed.
Yes.
EP was closed.
Yes.
Then how you are going to file another EP for this amount? For attaching the amount of Tirupati Nellore?
That amount was not paid. If that amount was not paid, there was no money in that Kala account.
But he has to take next
authority,
step. He has to take next step again at the same account only. He can't go for another account.
No. I am telling you, if you say you close that account, I will not put any money on that. Issue
Next
is
step
the
has to
authority.
take it,
PD is not an authority. Authority is NHAI or central government. So if your one PD is, they will attach the other. I am telling you, they have attached the central Kala account also.
Then it is a very problematic for
No,
Nellore
problematic.
account.
That's why the proper thing is we should immediately get the stay or deposit the amount with a petition that it cannot be released unless the petition is decided or can be released only on the submission of bank guarantee. There are Supreme Court decisions. We have got the decision in Punjab also where we have deposited the money, but it can be released only on the submission of bank guarantee. So we have to take all these actions. But we cannot say we will not deposit, let them attach the account, we will operate other account. That is the issue, na?
No, because of the Tirupati account, 4 accounts of Nellore was seized.
If we have not paid, the best course of action is we should deposit the amount with a stay that it should not be released if main petition is decided, or it can be released only for submission of bank guarantee. This is the best recourse available. Yeah, the landowner will submit. Suppose the decision came in your favor later on, then you can encash the bank guarantee. Na? That is the thing we are taking. No, we generally deposit the amount with the DJ. Execution petition is filed by DJ. DJ gives the direction to pay the amount. Either you deposit, and if they agree not to release till the main petition is decided, fine. If they say no, 50% is released, then you can say that you submit the bank guarantee.
Sir, one issue, sir. Sir, in one village, in the Kala proceedings, they have treated that one survey number as government, sir.
Okay.
Sir, but there are some structures existing, sir.
Yes.
Village is there. So later on in arbitrator award, the same thing which is considered in the Kala award, the same thing was reciprocated, sir. Treating it as a government land and 0 for the structures also.
Yes.
So that was the first instance of this first arbitration award, sir.
Yes.
So later on, after change of collector,
Yes.
the villages went to the collector and they have requested for compensation and all those things.
Yes.
Again, second arbitration was taken up, sir.
Yes.
So now the arbitrator has changed the nature of land and has given treating it as patta land. He has given value for the land, structure and solution also. We have challenged the second arbitration. The district court set aside that second arbitration award.
Yes.
So in order to take the land, sir, we don't have any what you call amount marked for that land, sir. How to take that possession? Nothing was awarded in Kala and in arbitration, in the first arbitration. In the second arbitration, the award was set aside by the district court. So how to take that land for the construction?
Once it is decided, you can take the possession. Who is stopping you?
Sir, but that village is existing and people are staying on that land.
No. There is a provision.
Sir, yes, sir, but sir, when we approach the district collector for the support of police and all those
Yes.
things, he is saying that I have passed the second arbitration award, but you people have challenged it in a district court. Then how should I help you? Like this is the
You approach higher authority.
Sir.
Next to government.
What is not allowed legally, how district collector can say I have allowed illegal things?
Sir, due to that, sir, we are unable to construct.
Simple is this.
Sir.
He is also a government officer. If he is doing any illegal thing, you have to approach next authority.
Sir.
But there is a provision. There is a provision which we have issued instruction. Any structure on government land can be compensated.
As an ex gratia. As an ex gratia.
It can be compensated. So why we have not compensated?
So ask the district collector to pass an ex gratia award proceedings.
It is not an award with solution
proceedings.
multimum, but it has to be an ex gratia award that the structures were there unless state government defines it as encroachment.
Sir, but state government is saying like they have given the patas earlier.
That's
Sir.
why there is detailed instruction on this. If they were given patta rights, then they are entitled for patta rights were given, then you have to give the compensation. There is no bar on that. Why we have gone for DJ?
Sir, this case is like this, sir. The Kala has not awarded, treating it as a government land. Then arbitrator also not awarded any compensation. Then next course of action is only if they are aggrieved party should go to the district court for the against the arbitration award.
Let me clarify. Issue is we just go by paper book or your simply theoretical. Kala has not given any award. So arbitrator cannot do anything on that. I have told you that arbitrator cannot include anything which was not in Kala. If it is proved that they are bona fide landowners with patta rights, we have to pay the compensation.
Who will pass the award again?
We can request
Kala cannot reopen the award. Arbitrator cannot reopen the award. Who will do that?
It is not reopening of award. It is purely passing a fresh award. It is not reopening of award. Once it is proved that land was in government only, but they were given pattas through a scheme of government, Kala only can pass a fresh award and we can pay. What is the issue?
Fresh award?
No issue at all. Government generally Kala issue a award of 0. But if we have to see the case details, bona fide things, whatever is written is good, detailed guidelines are there. In manual also there is clearly written.
Sir,
Hello.
If you have any confusion on this,
may I,
just
sir?
send it to us.
Okay. In this case, whatever situation he has projected, like the Kala has published a 3A notification as a government land. Okay. In that case, he cannot pay anything. Okay, the whole process has passed now. The 3G award has also has been awarded. Because of the government land, he has not been able to give any award. Now, how it can be sorted out? Again, we got to think yourself, you are a landowner. And you have got a patta for that land. And you are not getting money for that land. Obviously, you will be aggrieved. So even the Kala, he also has to look at that humanity point of view. A patta has been given to him, but by mistake, Kala has made it a government land. So now take up a case with the headquarter, give all the details, documents, and a corrigendum to that 3A. Whatever the 3A had been done, that has to be made the patta land. Once you have done the patta land, then again you will be giving all those 3C, 3D, you will have to pass through that. Again, you will pass through the same thing and make an award and sort it out. This is the way we need to find ways and means how to sort out. If we want to create a spoke, it is difficult. But if you want to sort out something in a good faith, I think nobody is going to hang you. So take that approach and send on a e-office or something to them. That will ministry, and in ministry it goes to the MOS. And if he is convinced, yes, it was a real patta land, but it was a government land, then obviously a direction will be given and the award can be given again. Thank you.
Sir, one more issue, sir. Sir,
Yeah, it's already court, it has gone to the arbitration again a court. District court, it has set aside the
Which PI you
arbitrator
gave?
award. Then second award, the arbitrator passed the second award because one arbitrator said there is no, it is a government land, no value should be given. And again the next collector, he has entertained the application which was closed arbitration, and he has entertained the application and again he heard and he has given the verdict. Against that they went to the district court. District court has stayed that. Now the problem is it is under legally it is stayed. Now what is that they can do now? That is the issue he has raised.
That as far as this case goes, there are two issues. One is whether they are entitled or not, or what is the legal course. We have filed application with DJ court that the arbitrator has wrongly announced the award. That is correct. But we know that the award should have been passed by Kala itself. So we should simply say that let Kala pass the award, we will pay it and take back our application from DJ. What is the harm in doing that? We are unnecessarily going for challenging without looking into merit of case and getting the burden of interest also, plus challenge up to High Court, Supreme Court. We will go up to Supreme Court. Once it is established that they are bona fide owners and they are entitled for compensation, we should take back application wherever it is pending and pay them. It is as simple as that. Unnecessarily, there is no point in litigating. But the issue is we are just opposing it, that we have to oppose it. We are unnecessarily fighting many cases. The arbitrator has not put his signature, but not on merit. It is okay that we are fighting that the arbitrator has not signed that thing or signed wrongly or something. But if we feel that there is a merit in the case, we should agree and give it. Because ultimately the aim is to give the proper compensation to the landowners and take the land. There is no aim to deprive the landowners of proper compensation. Unnecessarily we create hurdles, then the agitation is there and we are held up with our highways. So there is no aim to do it. We have clear aim that we have to legitimate jo bhi compensation, whatever is due, we should pay or minimize the litigation. That's why we are reviewing all the litigation 1.5 lakh arbitration and DJ cases. We are reviewing it. Wherever we can take a decision, we should take and move forward.
Sir, one more issue, sir.
Yes.
Sir, in 2017-18, that 3 capital A was passed, sir.
Yes.
After that, 3D was also completed.
Yes.
But one survey number was missed in that 3D, sir.
Yes.
So again, this project was again reopened in 2021.
Yes.
So during 2021, that 3G was passed, sir.
Yes.
So now, sir, like as that survey number was missed in 2021, when this that was opened, that person has applied for conversion.
Yes.
But that was not converted, sir. But we don't have any, like he's not showing any proof of conversion.
Yes.
That RDO was saying that that is deemed conversion.
Yes.
So now the case is, sir, like that is 6 acres of land, sir. So in that village, that arbitration is also completed.
Yes.
Arbitrators enhanced the amount to something 23 lakhs, sir.
Yes.
Now they are converting the nature of land. Why? Because he has applied for the conversion. So now they have converted land fit for house site.
Yes.
So now the amount itself is coming for 54 lakhs per acre.
Yes.
So after adding multiplication factor and solution,
8 crores.
it is growing up, totally it is coming up to 9 crores, sir.
Okay.
So from 23 lakhs, the amount has increased to 1 crore 45 lakhs per 1 acre, sir. So like in this case, sir, then how to tackle this, sir?
Why it was left?
Sir, that is a problem, sir.
Who is the responsible person for that?
Sir.
Once it was left, the 3A lapses. You have subsequently acquired it.
No, sir.
So why? Why that question of compensation comes?
So that is required. That is required in.
No. Required is different. Acquired is different.
Sir.
Whether you have issued any fresh 3 capital A for that?
Yes, sir. We have given to Kala, sir, but still he has not published that, sir. It is waiting with him.
If it is not acquired, your 17-18 3 capital A has already lapsed.
Sir.
Then where the question of compensation comes?
Sir, my question is, sir, that was earlier in 3 capital A. Should we treat it as agriculture or?
No. Once that 3 capital A was published in 17-18, it lapses after 1 year.
Yes, sir.
Then the land goes back to the landowner.
Sir.
They are in their right to get it converted. You cannot stop them.
Sir, issue is like this, sir. This 3 capital A published, subsequently they missed in 3D, and some years are lapsed. Then they found that certain 5-6 acres are left out. But that fellow intelligently has applied for a conversion, and he has given in writing that I will give it in direct purchase scheme. Then these people have sent the proposal for the direct purchase scheme. Then we said, he has paid the fees. As for his payment, there is a latest GO has come. Unless until the competent authority issue the orders, it cannot be treated as converted.
Okay.
But that order was not given. That was committed by the RDO and joint collector. We were not given any conversion order, but he has paid the fees. Then we have rejected his plea of that. He has not done the exercise, so it cannot be treated as converted land.
Okay.
Then it has gone, the direct purchase deferred, and it has gone off. Now that fellow says, because we have requested the joint collector to issue 3A before direct purchase, he has refused to give 3A. Then we have written in the letter also. 3A is a mandatory for the first going for the direct purchase. For 3A issue, then he has not done it. It is refused. There is a lot of political pressure on that, and they want this 1 crore 20 lakhs for each acre. They want to go to 9 crores. They want to this amount to be given. Then there is a lot of pressure on the district administration. They are trying to pass on to us. We have reverted it back, saying that all the provisions. Now they want what they say. Now finally with this they came to know that they have given now recently the conversion order. Now what they want to do is they will go for the 3A notification to legalize the thing. They will go for a 3A notification. Says that before 3A notification we have converted and we will issue 3A now. Knowing all the facts because on the record, because they are going to take the legal course and they will try to get the higher compensation on the guys.
आप बताइए सर पहले फिर आप बताइए पहले फिर I will let you. Similar case in Bangalore also. नहीं आप 3 कैपिटल ले भी कर लेंगे ना सर, प्रॉब्लम है आप उन्होंने अगर कन्वर्जन ऑर्डर कर दिया है, नहीं, then you have to come with a picture of malefied. You have to put, when we have sent you a request for 3 capital A, prior to that, you have not done that. Now you have changed up. Once it was rejected and it was supposed to be acquired by NH, then how you have converted the land? That proves the malefied intention. Clearly. Everybody will be in a soup. No, that is not issue. Once they have rejected it. If it was rejected,
That was not.
thing, no?
Sir, no, sir, not rejected. That was not rejected, sir.
That conversion was not rejected by the revenue authorities.
One minute. Then also there is a possibility. It was left out, but it came within your ROW.
Yes, sir.
Yes.
First, then you have to see who has left this. In 3D, why it was left? Whether the request was given by NHI.
Oh, that I will discuss with you separately.
Ah,
That is another issue. That is another issue.
That's
I don't
why
want
I
to
am
discuss here. But how we have to proceed?
नहीं proceed.
We are time and again saying you please
वहाँ
go
भी
for
आप उसको malefied. You can prove malefied that once it was coming in ROW, the conversion should not have been accepted and should have been rejected by
इसमें
state
तो अपने
government.
लोग भी फंसेंगे फिर.
सर,
Once
सर,
it was notified in 3, why how it is missed in 3?
इसीलिए
इंक्वायरी होगी तो अपने लोग भी फंसेंगे, काला के भी फंसेंगे जो काला के नहीं होंगे.
इसीलिए ऐसे इश्यूज में प्रॉब्लम है. देयर आर, इस पे मैं 2-3 केस की इंक्वायरी ऑलरेडी कर रहा हूँ, आई विल लेट यू नो. इसीलिए मैं कह रहा हूँ ना, ऐसे केसेस में बड़े इश्यूज.
और अगर थोड़ा बहुत फर्क होता तो मैं मान भी जाता है. भाई 2 करोड़ का 9 करोड़ कौन देगा, कौन आरोप दे सकता है?
मैं आपको केसेस दिखा दूंगा, मेरे पास बहुत सारे केसेस हैं. दैट्स व्हाई आई एम टेलिंग यू. हमारा डेली रूटीन है सर. आपको ऐसे ऐसे केसेस दिखाऊंगा, आप कहेंगे क्या किया हुआ है. बहुत सारे हैं सर. तो इसलिए ये इस फोरम पे आप कर नहीं सकते. देखिए इसमें एक ही है कि आप जाएंगे तो यू हैव बोथ इश्यूज. आपके अपने लोग भी आएंगे और बहुत सारी इंक्वायरी होगी.
आप ये बताइए डीम्ड कन्वर्जन पे आपका क्या कहना है?
स्टेट गवर्नमेंट की जो पॉलिसी है,
गिवन एप्लीकेशन, ही हैज डिपॉजिटेड द
अगर
लैंड
ये
कन्वर्जन
स्टेट
चार्जेस.
गवर्नमेंट की पॉलिसी में है कि डीम्ड है, यू एक्सेप्ट दैट. नहीं है तो नहीं.
बट अभी 21 जुलाई की इसमें एक नई गाइडलाइन आ गई, उससे पूरा क्लियर कट उन्होंने लिखा, उसमें कहीं डीम्ड कन्वर्जन की बात
नहीं है तो नहीं है. देखिए जो
भानु जी
जिस
जो
समय
डीम्ड कन्वर्जन वाला था वो कौन सा ऑर्डर है? वो तो पहले का है ना.
98 पहले का सर.
98
जो भी चीज एज ऑन डेट
2021 से नया ऑर्डर आया था, एक्ट हैज बीन अमेंडेड.
उसमें तो नहीं है डीम्ड कन्वर्जन की बात.
नहीं सर.
तो सर जो 3 कैपिटल ए की डेट पे जो भी गाइडलाइंस, जो भी पॉलिसी इन फोर्स है, इट हैज टू बी फॉलोड
इफेक्टिव फ्रॉम 2021.
जो भी जिस डेट को जो पॉलिसी इन
if it is
फोर्स.
effective from 2021, then his previous conversion of 2018, it is will be a retrospective, which is not.
No,
That
no,
it is deemed.
That is deemed conversion.
That is
That is deemed conversion, then it is he is eligible. 18 का है.
18 का सर. 18 का 98 GO. Then 221, then again there has been amended. No, sir. After 2021. That is what, that application is not valid unless it is done.
Simple whatever simple rule is there, whatever law was as on date of 3 capital A, it has to be followed. Simple is that.
In this case, 3 was not done for that survey number. You cannot claim that three to हुआ ही नहीं. But it was lapse, na? It was lapse. We have not taken that land. लैप्स हो गया ना सर, पूरी प्रोसीडिंग लैप्स हो गई. इट वाज आवर फॉल्ट ना सर. ये हम अलग से इसको डिस्कस कर सकते हैं, उसके बहुत सारे वेज हैं जिसमें उसको पकड़ सकते हैं. Now we are getting late for the lunch, I think. Before that, I want to read some provision of the act, as someone was asking. And thank you, sir. Thank you for detailed presentation. Thank you so much, sir. No, somebody was asking about the provision, applicability of Arbitration and Conciliation Act 1996. Under section NH Act, in NH Act under section 3G6, it is clearly mentioned that certain of the Arbitration and Conciliation Act 1996 shall apply to every arbitration under this act. Now, I am connecting it with the Arbitration and Conciliation Act. First thing is limitation. Somebody was asking, is the provision of Limitation Act is applicable to the arbitration under NH Act? Now, here is the answer. Under section 43 of Arbitration and Conciliation Act, it is written, the Limitation Act 1963 shall apply to arbitration as it applies to proceeding in the court. Okay? Yeah. Next question was that the duration, where it is mentioned. In Limitation Act, you will go to the schedule first and article 137, it is clearly mentioned, there is a provision of 3 years. The other application for which no period of limitation is provided elsewhere in this division, 3 years. The time duration is 3 years. Now it is clarified. The limitation is 3 years. The provision of the Arbitration and Conciliation Act applies to the NH Act. And apart from that, definitely I am coming to this. Time limit for the arbitral award. Time limit for the arbitral award, it is 29A under section Arbitration and Conciliation Act 1996. It is clearly written, the award in the matter other than international commercial arbitration shall be made by the arbitral tribunal within a period of 12 months. Within a period of 12 months from the date of completion of pleadings under sections, subsection 4 or subsection 3. It is clearly, you will go through the act. I have mentioned the provisions under act, under several acts. You will interlink it and you will find the result. Why we are saying that? Oh, yeah. But arbitrator are keeping it, keeping pending it from more than hearing is completed. Arbitral award, we are waiting for the arbitral award. Most of the cases we have observed, the arbitration award is finalized after 5 years, after 6 years, although the hearing was completed. Although the arbitrator reserved it for the order. But even after passing of 5 to 6 years, they have not released the order.
No, the only issues, generally the pleadings are not completed. Your issue is that only, no?
Okay.
So in that case also, we should file for petition stating that within, there is some time limit prescribed in section 4 must be there.
Coming to that.
23 में निकालो ना उसमें होगा section 4. कोर्ट्स में नहीं, हाई कोर्ट में.
कोर्ट के लिए नहीं है सर. कोर्ट के लिए नहीं. कोर्ट के लिए.
5 साल से करेंगे. Agree to.
No, I am coming to that, sir. I am coming to that.
ये तो कोर्ट ऊपर है ना.
हाँ सर.
ये ना देखिए.
नहीं मैं
J&K में किया है.
J&K में किया, बट वो अपने अभी है. मैं ले आ रहा था सर. हाँ, वो 60 डेज के लिए रेफरेंस का है सर, जब रेफर करते हैं. आई विल शो यू. हाँ नहीं सर, वो नहीं है. आई विल शो यू. मैं आप लंच के बाद आपको दिखा दूँ. I will show you. Okay. हाँ.
We'll move for lunch. We'll reassemble again at 3 o'clock. I request Chaturvedi ji to please present.
It's okay. I will. Before I start this presentation, I wanted to discuss that, where we left that. Huh? What we have read under section 29 of A, time limit for arbitral award. Here clearly mentioned, the award in the matter other than international commercial arbitration shall be made by the arbitral tribunal within a period of 12 months from the date of completion of pleadings under subsection 4 of section 23. Now, what is subsection 4 of section 23? It is important. It is related with the statement of claim and defense. Now you will see what is subsection 4. Subsection 4 is, no, here. Acha, okay, sorry. Okay. Now here subsection 4. What subsection 4 says? Actually it says the statement of claim and defense under this act shall be completed within a period of 6 months from the date the arbitrator or the arbitrators, as the case may be, receive notice in writing of their appointment. Means, after appointment, both the parties, the claimant and the defense person, has to submit their claim within a period of 6 months. After submission of the statements, now arbitrator has to decide it, complete the proceeding within a time limit of 12 months. So, when the case refers to the arbitrator, it means both the parties have submitted their pleadings, then the arbitrator has to decide the case within a period of 12 months. Now it is clarified? No, since appointment, then we will consider it would be 1 year and 6 months. For 6 months for submission of the claim. Yeah, definitely. It is mentioned under Limitation Act. Yes, both are there. In such cases, if there are 2 guidelines, then we generally consider the higher one. Now the topic is land arbitration and court cases module. As we have seen at headquarter level, there are more than 2 lakh disputes cases are pending. It's a huge number. It is a great concern by the senior officers, even by the ministry. Pending of litigations at various level, at arbitration, at DJ, at High Court and at Supreme Court. And there was no such mechanism to monitoring these pending cases at the level of headquarter, either at the level of RO. We do not have such a mechanism to monitor the court cases which are pending before the courts. To address this issue, we have proposed to development of a module, LA arbitration and court case module on the data lake portal, where we suggested to incorporate all the case details. An advocate has to enter all the case details on the portal so that we can review the matter. An advocate has to enter the detail of the court cases and the detail of hearings. Thereafter, the authority at the level of PIU, at the level of RO, at the level of headquarter may see how the proceeding is going on and how better we are defending the case and how better we are defending on the merits. Either we are defending the case on the merit or not. So, a portal was developed. I am elaborating the procedure, how the case is entered on the portal. First, we onboard the advocate by RO. It is something making a panel of advocates at the level of RO, and thereafter PIU allowed the cases. It means PIU propose the name of advocates along with the case and send it to the RO for the approval of advocate. Once the approval of advocate is done, the concerned advocate will get the credential of such as login ID and password on their mobile as well as on their email address. And with due course, also the advocate enters the case proceedings as well the details, and after disposal of the case, the advocate may raise their bill and it is further get approved by the payment by the authority, and further the payment get credited to the account of the advocate. Yeah, definitely, it can be raised. Yeah, actually. While during proceedings, the advocate may raise their bills. Generally, what we observed actually, advocates are submitting their bills even after 3 years, after 4 years, after disposal of the cases. That's why I mentioned that actually. We have observed that the advocate just raise their bill at a one time, and in most of the cases they has to produce certain documents, certain things they have to produce for the finalization of bill. So they may raise their bill even after a few hearings. We have provision under data lake module. See how onboarding of advocate done. The module keeps detailed information on the onboarding and deboarding of advocates. Law firms are providing a historical view at a different time period within NHI. RO can initiate the boarding process for advocates, law firms, while LA division can access the complete list of impaneled advocates, law firms. RO login at the level of RO. This provides a historical view of advocates engaged at different time period within NHI through the data lake portal. For instance, SKP associate was onboarded, and you are seeing here. Was onboarded in year 2016 and de-onboarded in 2018, reboarded on in 2019. The cycle of event can be viewed in detail in boarding section of the advocates. The system also handles automatically deboarding based on the disengagement information. For example, if the RO provides deboarding dates during the engagement, the advocate will be automatically de-empaneled on the specified date and won't be able to log in the data lake. If an advocate continues with other cases, they can only update the hearing status after reboarding by the RO. At PIU level, after engaging advocates, the concerned PIU should add cases with necessary information. Select 3 preferred advocates. As I have mentioned, PIU has to suggest 3 advocates' name while assigning a case to the advocate. The concerned RO can then approve the best advocate among the 3. Based on the performance, there are the criteria in which advocate in which RO can see the performance of advocate. Each advocate performance can be viewed by the advocate, RO. During this process, both the PIU and RO can assess the performance of the advocate in previously assigned cases, such as the number of active cases, cases disposed of, and the percentage of win and loss. It is also a criteria, win and loss. Additionally, there is a provision of assigning multiple cases from the same village to a single advocate. See how it looks like at the level of RO. He can easily see this window, and in which he can, in this dashboard, he can see the pending advocate approval cases, in which the compliance, advocate performance monitoring, other things are there. Here is the payment process in data lake module. Invoice submitted by the advocate, sent for the scrutiny to the finance and account division at PIU level, sent to the PIU for bill approval, that is go to the PD, approve and initiate payment to the finance and account section, first signatory, IEV prepared for the first signatory, payment credited by the second signatory, payment released by the RO by the second signatory, and then thereafter payment credited. Linking of case, the portal offers a detailed history of individual case proceedings. In some matters, at the level of arbitrator, we lose the case or we win the case, and thereafter further the landowner goes to the DJ, district court. In this portal, we can link those cases with their previous history, where what was the field, what was the grounds on which we have fought in the arbitration. So it is quite easy for the further defending the case in the further higher courts, including its linkage to the matter of the lower courts. In case is under consideration for challenging in Supreme Court, it will be possible to view the case history in lower courts, analysis why this case has been challenged at different lower courts, such as arbitrator and district court and higher court. At the level of advocate, the dashboard appears like this. At the time of onboarding, advocate received the user ID and password as I told, allowing them to log in the data lake portal to update hearing status and raise bills for hearings. This enables stakeholders that like PIU, RO and LA division to view the real-time status of the case, hearing including the number of bill raised and their payment status. These features shall expedite and resolution of cases. You will surprise, we have there are more than 20,000 bills have been raised on the data lake portal, and more than 38 crores amount have been passed within 6 months. See the litigation cost. See the litigation cost. I think we should analyze separately. There are certain reports on the portal, like performance monitor of an advocate. You can see advocate name, RO, where it is engaged, total number of cases performed all over the India. Now with this recent policy, there is a provision of firm, a legal firm may only get 2,000 cases. And an individual advocate can get only 200 cases. If we include the bunch, it would be 300 cases. Now considering that parameter, we have created this portal. With the help of this portal, at the level of PIU, at the level of RO, it can be easily monitored that how much cases have been assigned to the concerned advocate. Active cases disposed of, number of cases win, number of cases lose, and what is the performance rating of advocate. Another report. All stakeholders can thoroughly review the reporting grid to observe the number of cases assigned to the advocate, wherein it is a single case or a group of cases, that is bunch cases. Stakeholders can click on the view option that access comprehensive detail of the case, including the project name, code type, 3D, 3G. These are some credentials which need to be entered on the portal. Notification, plot information, hearing status details, payment disbursement, and advocate engagement history. The module contains a library of several reportable courts orders for simpler previous cases which advocate can use in their current cases as when needed. This module plays a pivot role in the identifying similar cases, adjournments, analyzing past mistakes, and offering insights on the preventive measures. Real-time analytical reporting. It is analytical in the analytical report section, current court cases are presented, categorized by their RO, including the pending and disposed cases across different courts like arbitration courts, district courts, high courts, and supreme courts. This information is available in the both textual report and GIS environment. Textual report and the GIS environment, allowing for the nationwide view of the court cases pendencies through maps incorporating in the project. We can see how much litigation are pending in a particular project. Produce the GIS. Detailed report with the plot, khasra number detail are also displayed in a GIS environment with the following information. ROIs, total cases, arbitration, DC, and High Court and Supreme Court. Here we can see in this particular survey number, we are litigating. The case, court case is pending. The case number detail are mentioned here. In data lake module, these credentials can be entered and easily viewable while analyzing the case. Some petitioners filed cases claiming higher rate of proximity of land to the national highways. The module provides functionality to concern an HI division to verify in real time the actual proximity of the land with the accurate measurement in the GIS environment. We have also this feature. In conclusion, the module functions as a centralized platform for managing the advocate engagement, provide a real-time overview of the court cases across various courts like arbitration, high court and other higher courts. Stakeholders can access the real-time updates on the case status, hearing decisions and advocate payment disbursement, ensuring everyone is aligned. This unified approach minimizes confusion, ultimately expediting the resolution of court cases. Thank you. This was a quick recap about the arbitration module. We will take the issues which we are facing on the arbitration module. We have advocates actually. How many of advocates have raised a bill on this data lake portal? Are you facing any problem?
So after that, again we have to start from the beginning.
Okay.
So it will take hours together. In one case, some number of adjournments are there. So it will take 1 hour, 1.5 hours sometimes. So website we have to verify, and if it was upload log out, so it will start wherever the.
We are working. Actually, we are working on that. Soon you will get that updated on the data lake portal. If somehow in between the process of entering the details, somehow you get log out, then automatically whenever you will log in again, you will get the same page.
Same page, it is somehow it is better.
Yeah.
So when
we are working on that. Apart from that, any other issue?
Column is the CNR number. Unless we fill the CNR number, it's not loading. Error, it is saying it 16 digits has to be loaded. We are not having any CNR number. For all the not some cases, it is coming. CNR number.
I think in most of the cases where it is pending at DJ, it is this issue with the arbitration cases?
No, I will show you this. You will be getting
no, yeah, definitely.
All cases not there, sir. All cases not there. Only for few it is coming CNR.
Okay.
Because of this, we are not in a position to load.
Sir,
it is not for all the cases.
CNR.
In some cases, it is CNR number is coming. No, sir. Not every case. For some cases only it is there. Not for all the cases. No, maybe for high courts it will come, but DJ it will not come. CNR number is not there for DJ, sir. That's why it's not loading. When we are saying want to load it arbitration open number at district level, it is not loading asking for CNR number. CNR number, if you putting our case number, it is asking for 16 digits, the error. High court may be having, I am not having, I am not practicing.
Curling. Minu, note down the issue. Actually, that is. Sir.
A case is allotted to me in High Court, okay? And on the first day, I have convinced the court and get the case closed.
On the very first day?
Very first day.
Okay.
So now the issue is, now I can only upload the main petition of the petitioner along with the material papers. Now I don't have a counter, I don't have written arguments, I don't have anything other than the instructions sometimes given by the PD sir from the concerned PIUs.
But it rarely happens.
No, it happens.
On the very first day, the court has produced.
No, let me explain.
Taken decision on.
I am given,
anyway.
I am given 8 cases.
Okay.
Out of the 8, 5 are disposed on the very first day. Today also morning one case got disposed. So
Congratulations, and you,
my-
RO sir must have praised this.
my difficulty is now I am not able to close it.
Okay,
I
okay.
am not able to raise the bill also. No, my concern is not with the bill, but the system needs to address this issue. And the second aspect is,
It was not assumed that the case will dismiss or dispose on the very first day.
but there are many instances.
Yeah.
of that. Yeah.
We will
Now
include
we
this.
can have some provision.
We
He is
will-
new advocate. I have just appointed him.
No,
Just
very-
1 month back to my.
Okay, sir.
I have pointed out certain improvements in the data.
And he is very active.
Okay, okay.
He is very active.
I was a software engineer also earlier.
Okay, okay, okay.
The other second issue is,
Huh.
now 90% of the cases, we usually don't file written arguments unless it is a complex legal issue or some issue which actually prompts us to file written arguments so that if judge does not consider issue, we can say that, okay, this legal issue is also argued before the court. The honorable judge did not consider. So other than those cases, we will not usually file written arguments. But our portal says you have to upload written arguments, otherwise this will not be closed in the case closure page. No, I actually wrote it.
हाँ बताइए, what is the issue?
Sir, usually cases are in High Court. Some cases are getting disposed in the very first instant itself.
Okay.
So the portal is not allowing me to close a case without uploading a counter, written statement of me and written statement of the petitioner and other things. So I am forced to upload the same petition again and again to close the case. So we have to make it as optional, saying this got closed in the first instant itself in the data
then
lake portal.
one issue is this, other issue?
So the other issue is
Written argument. You are saying
Yes,
some
sir,
written arguments.
written argument.
Basically your issue is, in every case you don't have every document. This is the issue, na?
No, written arguments are not there itself. No.
In every case you may not have every document available because of first hearing, disposal or something. You just upload a plain paper writing that there was no written documents or available, or
It must be verified by the PD, actually.
Just.
It must be verified by the PD.
No issue at all. You just put a plain paper, write there what is the issue and upload it, that will cover your issue.
Yes, sir, that
At
will
least we should have some record, na?
yes.
Okay, why it is not uploaded.
Yes.
Something should be there.
Yes, sir.
That's why it is kept mandatory. Otherwise, nobody will upload any document.
Yes, sir.
So once you are uploading a paper, then it becomes undertaking that this is the reason why we are not uploading. So that will
Portal
close.
is not a human being, so you have to upload something.
Something. No? No, otherwise also we will not know na, why it is not
That
uploaded.
is true, sir. That is true.
Please do not attach the blank paper just. It is
That
not
like-
going to help us.
What he is telling us, he will write the same thing on the paper.
Yes, yes.
So that
No
anybody
issue.
can download
That's-
it and.
But it must be verified by the PD, actually, sir.
When they
Some
are
verification
making,
must be there.
payment to bills, they will see what is why it is not.
No, my endeavor is we may make it as an optional rather than
No,
making
that's why once we make it optional, na, nobody will.
You
upload
must
it.
be informing to your PD also, na? When the case is disposed
Once
of, even on
we
the first
make
day.
it optional,
So if you are
Somebody is
informing the
going to
PD,
upload the
you just
data.
take a screenshot of the mail ID and please take the printout and upload it.
Yes.
once we make it optional, nobody will upload it. That is the issue.
Sir, and the second aspect, the grouped cases.
Yes.
For example, in arbitration in a particular village, there are 26 or 30 cases.
Yes.
So, as of now, they are being shown as non-clubbed cases in the portal.
Mike.
They are being shown as non-clubbed cases in the portal, sir. So that should have been done by the concerned PIU while allotting the case itself, or there should be a provision given to the advocate to say, okay, these are the cases pertaining to same village, same award.
That provision has been given at the PD's end. They have to club the cases. So, at the PD end, while allocating the cases, they have to do the bunching.
So that is one thing that
That we have already catered for in the portal. We will tell the PDs to club these cases.
Advocates can also discuss with the
Yes.
PD and accordingly then after in consultation
If
with PD,
any issue
that
is
can
there,
be
we
clubbed
will, our technical person will help. There is a provision, you first enter one case, and if you want to add the same cases, you can add under that only.
Yes.
There is a provision.
And there is another thing wherein at the very initial stage, we will have a filing number.
Yes.
Not main case number.
Okay.
In the portal, we have 2 case numbers. So it is not specified, saying it is a main case number, or in trial courts it is GR number. In high court it is SR number. So this particular aspect is not properly addressed in the court. So the 2 main numbers are being entered repeatedly. For example, today I am filing a case, sir. So I will get a SR number first. I will not get the main number. Main number will come after 2 or 3 days after scrutiny of the concerned registry. So this particular aspect is not being addressed in our portal per se, to say there are 2 case numbers, but both are main case numbers only.
No, final case number would be allocated once it is admitted or something, na?
Numbered, sir. Scrutiny. But as on the date of filing itself, we are uploading the case saying, I mean, this is the case.
Why we are uploading on filing itself?
There are some cases which scrutiny will take some time in order to
After
make
that we can upload, na?
No, my endeavor in submitting that is we can give 2 case numbers. One is filing number, another is main number, instead of giving 2 case numbers.
Okay, let me check with our technical team.
Yes, sir.
Besides, if it is possible, we can do.
Yes.
No issue.
Yes, sir. Filing number, sir. Filing number. Yes, sir. Yes, sir. Sir. The first one comes from the allotment from PD or RO, sir. Yes, sir. So that way.
So that must be the filing number only.
Yes,
na?
sir. Only small change there, so that there won't be. So the other aspects, sir, with respect to, for example, High Court, there are writ petitions, writ appeals, or CRPs, or criminal appeals. So there are case types which are more in number.
Yes.
In trial court, district courts, AOPs are and execution petitions and suits, if at all there are some cases. So the case types, because we are asking number to type, manually, without having a drop-down box, because these are the case types that needs to be taken by the system through a drop-down. Because I can enter any case number. OS is the usual prefix for any suit, but I can issue OSS also in the system. That checking mechanism should be there in the drop-down box.
We have already, I think there is a provision from there is a drop-down menu for each high court, the type of cases. We have already, I think it's there.
I have gone to, I'm sorry, sir, it might be there, but
I will also check. If not there, we have made a provision where all the high court cases, you can select from drop-down and just enter the number and year.
Yes, sir. And the other point, sir, in the data lake portal, a particular stage of the case is not being specifically reflected. For example, today, one case is being allotted to me in High Court.
Yes.
So first PDSR sends me an wakalat and then sends instructions. And if the court requires there should be counter, then a counter being sent by the, after send the draft, it will be sent to the advocate.
Okay.
And then arguments. Sometimes, recently there is a case where there is a stay, but the court gave a judgment after reserving almost 16 months. So in that case, advocate role ends on the day of submitting final arguments. So in order to reflect the exact stage of a case, we need to have a mechanism in the portal, even in the advocate login also. I'm not sure whether it is there with the PIU or RO login, but in the advocate login also, so that when I open the page, okay, in this case, I don't need to do anything. It is only
Understand.
the binary, without having the binary things. And
basically, you want for every stage, they should reflect at your portal also as well as PD portal also.
Yes, sir.
What is the status of case, at what stage it is pending, and what is the role of advocate or PIU at that time.
Correct.
That you want, no?
Yes, and the last.
Give us in a writing
Yes,
the
sir.
details. We will get it done.
I already wrote it, sir.
हाँ, वो ले लो उससे.
I'll send a soft copy also.
इसको करा लो. That will help in compliance also.
Thank you, sir. Thank you.
If the affidavit is pending at PIU to approve it, they can approve it. Yeah.
Sir, in data lake, there are only 4 columns. We can fill it up only regarding land acquisition case under the 5 heads. If any third party has filed a case against us, there is no column to fill it to that
This
third
portal
party.
is for land acquisition cases only.
Supposing all the NH means third parties also filing cases against the NH. For that, we are not in a position to load. Any other case, you can add it.
This portal is specifically designed for land acquisition cases only. Other module has already been prepared in data lake where you can upload other cases.
Other cases is not there, sir. I am not loading except this only. 4 or 5 columns. And if third party has filed OS or EP against the national highways, I can't load it.
No, this I am telling you, this is for land acquisition only. This portal, this module is for land acquisition case only.
No, sir.
No, no.
No, sir. Even other cases they are filing against the NH.
This
Supposing
portal,
accident cases are filed against the NH. Or some the party filed suit against the NH, adding as a party. No, our land is acquired by us. In partition suit, they are saying it. Land acquired by NH, sir. In family dispute, they went to a court, civil court. There we have added as a party. In that case, we are not in a position to add.
these have not to be uploaded. We are not a party to any ownership cases. We have to submit application immediately that NHI is not a party. NHI has already determined the compensation and paid the to Kala. Whatever dispute relating to ownership is there, they have to.
That we are contesting in the court, sir. What I am saying is that details we can't load in this data.
This because that is not related to any land acquisition.
Why you are contesting? How we are party?
No, they have added as a party, sir. Because
We have to tell them.
We have filed a counter, we are contesting the case. What I am saying is, in those cases, we are not in a position to load.
Why we are contesting?
What he is saying, why you are contesting? You should be
because they have added as a party.
No, just you simply file an affidavit that NHI has no role in determination of ownership of a particular plot.
No, sir. In case of disbursement of the amount.
Disbursement,
that's why they went to court.
Just.
That is regarding apportionment.
And
regarding ownership, dispute between ownership. So how NHI is related?
They have added as NHI as a
party. No, just you simply file an application.
Why you are not understanding? Please understand. You have been made a party. Please tell the court I am not a
no, sir,
necessary
already
party.
We are filed detailed counter. We are no way connected. We have disbursed the amount as Kala. We deposited the amount.
Okay.
It is their duty to look into the civil court, concerned court to disburse the amount. What I am saying is such type of cases we are not in a position to load it in data lake.
मतलब एक बार तुम counter बताएंगे ना? We will inform the court that we are not a party.
Counter भी क्यों बताना है?
When we are
not required at all. We have just to simply file an application.
You are a party, na?
We are a party that has to be dealt with independent of this portal. We don't have to engage advocate also. No. No.
Don't fill in such cases in the portal. You go manual. Okay? You need not
all
to enter
cases
into the portal.
which are not related to payment of compensation or anything. They have to be dealt with separately as per your manual procedure. They don't have to be entered on this.
No, even consumer case also we are not in a position to load it.
No. This portal I am telling you is specifically for land
acquisition.
acquisition.
Saying it only for land acquisition, we will stick on to that.
This is specifically for land acquisition. Status क्या है इनका पेंडेंट? वो दिखाओ इनका एक आरोप का जो है ना वो निकालो. पेटिशन वाला कहाँ है? यही है. जस्ट सी नीचे ला टोटल लोग ना. नहीं पेटिशन अपलोड का इनका टोटल नहीं किया, कितना किया है. Not uploaded. Which is not uploaded? 107 not uploaded. कॉलम कौन सा है आपका? हाँ हाँ, और 191 क्या है? 1067 is not uploaded. Is uploaded है ना सारे? अच्छा ठीक, फ्रीज कर दो. फ्रीज पेंस हो ना, ये ना आया तो था. नीचे चलेगा, ठीक है ठीक है, नीचे चलेगा, जस्ट गो. Just go down, go down. Bottom में चल जाएगा. Just there are 3079 I think arbitration cases are there. NHI petitions uploaded only 207 and opponent petition only uploaded 191. So why other petitions have not been uploaded? Because without petitions we are unable to analyze the cases. So reasons for not uploading the petitions and everything.
Advocates,
what is the reason? That has to be uploaded to advocate side. Reasons? Advocates मेजर किसके हैं? ऊपर चलना. PIU I think.
एंट्री बहुत कम हुआ है ना.
बस राजवेंद्रम 545 only 72 uploaded, 71 uploaded. PD आपने कभी देखा इसे? Have you seen it?
Any advocate from PIU Rajmundry dealing with PIU Rajmundry?
नहीं वो तो ठीक है सर, बाकी भी तो है. McKinney का तो छोड़ देंगे. हाँ नहीं, that okay, that is there.
Yogesh ji, you are having 191 cases.
191 लक्ष्मीनारायण सर एलिवेट होने के बाद ट्रांसफर. जैसे उसमें 70 डिस्पोजल हो गए सर एंड 69 रिजर्व. आई हैव अपलोडेड ऑल द पिटीशन कॉपीज. some of them are reserved for orders.
The only first request is at least complete the data, uploading of data on this portal. That is the first requirement. We are doing this for last 1 year, but still now the petitions have not been uploaded.
Sir, can I submit, sir?
Yes.
Sir, in our case, sir, for the old cases especially, when we are trying initially to expedite the onboarding, sir, we have not uploaded them, sir. And when next time when we are tried to upload, sir, it is not allowing, sir. It is freezed, sir. So that petition copy we are not able to upload, sir.
No. At advocate end, we have issued a circular for payment of 300 rupees also, April and May.
Yes, sir.
Clear 2 months. Still it was not uploaded.
From PIU login, it is not possible, sir. We have checked it, sir.
That we are planning to do it, but from advocate side, what is the problem? No, they have already uploaded the case.
Case means
that
only general details were uploaded, sir. That
general
petition
details
copies
were uploaded. You have allotted the case to advocate.
without petitions.
No issue.
Yes, sir.
You have allotted the case to advocate. Now have to upload the petition. What are the problems they are facing, na?
We have no option.
Have you discussed the matter with the advocates?
So it is possible for them to upload.
112
For us,
cases
it
were
is showing gray.
allotted to me.
Gray.
23 I have uploaded, sir. 89 not matters are there, and majority of cases were already disposed of. Disposed cases I have not uploaded, sir. Pending cases I have
No, your
uploading.
bills are pending?
Some bills
For
are pending.
disposed cases, your bills are pending or it is
In
cleared?
some cases, bills are pending, sir.
Wherever bills are pending, you have to upload the complete document in a single upload. But documents have to be uploaded, otherwise payment will not be made. PIU Chittoor, there are around 1600 cases.
That is the problem, sir. I was trying to tell. Disposal status, sir. I will get it done, sir. Disposal we are doing now, sir. We have left
Not
only
just
300.
dispose.
Sir.
Issue is secretary sir is reviewing every 15 days. We have to analyze the cases and give him a feedback that this is the cases and these are type of issues which we have to see. Unless petitions are there, we are unable to do any analysis. We have issued an instruction for analysis of 20 cases per day. That has also been not done. We are getting the petitions uploaded from all over India. 1/3 petitions have already been uploaded. It is a long time. Here you are handling only, I think, 3,000, 4,000 cases. ROs where cases are 25,000, 24,000. There also the petitions have been uploaded. That's why we specifically gave a fee of 300 rupees for uploading. So kindly upload these petitions in next 1 week or 2 weeks, because it is required at the highest level. So PDs kindly see to it that all the documents are uploaded within next week or next to next week. Analysis of 20 cases, what is the issue? Any PIU has done it? No PIU has done it.
Sir, we have sent 50 cases each, sir, from each PIU.
It was to be done 20 cases per day. Or one bunch if you take, one village case you will take, you have to analyze only single case. At least your legal support officers you are having, they should analyze and come to you with the brief of that case. Advocates, kindly let us know the issues which you are facing. Otherwise, how we will move forward? कितने केसेस हैं? चेंज हो रहा है क्यों हमारे पास? जो दिखाओ. There is difference of data uploaded on data lake as well as what is provided by RO also. Around 3,395 cases are reported by RO, whereas in data lake it is around 5105. As per our record, it is 6432. So what is the reason for this discrepancy? PDs ने चला के देखा है कभी portal? Have the what is the issue you are facing? You should just give us detail, na? We will get it deleted from backend, na?
Yes, sir. That is the issue, sir. Initially, due to we are not aware, ki only compensation.
No, not an issue. But whatever cases you feel are not to be uploaded, give us the details. We will get it deleted from backend.
Okay.
But why the documents are not being uploaded? Time and again we are issuing instruction to get it uploaded, but it is not uploaded. Age wise dependency hai? नीचे जाना है से 10 वाले में 362 cases are pending for 5 to 10 years. More than 10 years, 275 cases in arbitration. ऊपर चलना ऊपर 275 कौन रहा है नीचे नीचे देना blank. Okay. 5 to 10 years. This is Babu Rao. 38 cases, 5 to 10 years. Which PIU is this? 33 GVK D Kumar, GKV D Kumari. These are your cases, madam. Why these are pending for 5 to 10 years? Any specific reason?
No, sir, because I have been unpaneled in the year 2022 itself, but some cases were allotted to me from the where Justice Lakshmi Narayana sir has been elevated to High Court, and thereafter those cases, some of those cases were allotted to me. I have unpaneled in the year 2022 itself.
No, these are pending for arbitration, na? After 22, also these are not disposed of.
I have been appointed as a panel advocate.
When these cases were allotted to you?
In the year 23.
23?
Yes.
Still not disposed of?
Some of the cases were disposed and some were pending. Most of the cases were disposed.
I am asking for specifically these 33 cases which are pending for more than 5 to 10 years.
No. Those are not pending from 5 to 10 years.
Which PIU?
I am dealing with only PIU Rajamandri.
PD.
Arbitration cases.
Having additional charge, na?
हाँ कोई बात नहीं. Somebody is in knowledge of these cases pending for 5 to 10 years. We just want to know.
The arbitrators has not been taken up the cases for hearings, sir. The no hearing we are being
What
conducted.
action you have taken for expediting the arbitration hearings? Any letter written to arbitrators?
No, sir. No.
Brought to knowledge of RO? Nothing.
No, sir. particularly in GDK project, the arbitrators are not taking interest.
Arbitrator are busy persons, they are not taking up. But have we taken the issue to them?
क्या है कि पेमेंट का नहीं होता ना, without entering into the data lake portal they will not get any payment. So all advocates, please note, you will not get any payment released by the PIUs. And also I am asking PDs, please don't release any bill to the advocate until unless it is posted all the documents on the portal. It is now mandatory.
It is
take it as a special drive, and within a week or 2 weeks time,
if
please
you are
get it
facing
posted.
any problem, we are here to help you. But not doing is not accepted. If you are having any problems with the portal or any clarification or something, we are ready to help. But not doing it just for not doing, that is not accepted. Neither the payment would be made, even the cases would be allotted to some other advocate also, if you are not doing it. Clear instructions are there from the top only that unless the advocates are doing their work properly, take away the case, give it to other advocates.
Entry ka bhi to I think we are giving some money. Na?
For April, May, we have given 300 rupees per case. Despite of that, that has not been uploaded.
We are not giving money, this 300 rupees. One time relaxation दे दीजिए, फिर इसको हम करा देते हैं.
Only 20, 23 and 25 cases are pending with my.
We can give you, but let us know na. अब ये होगा कि क्यों नहीं अपलोड हुए? That is the issue. कि why not in April, May? That can be considered not a big issue, but issue is still that would not be uploaded. If they complete the work and you send us the proposal that they have completed, you allow them one time, that can be considered. But unless the work is done, then we again extend it and then again we...
How many cases are pending? Not uploaded?
Around 5,000, only 10% or 15% only it has been uploaded. It is a huge chunk where it has not been uploaded.
PDs also can cooperate with the advocates. थोड़ा सा आप help करिए
PDs,
आप लोग,
you have a meeting with the advocates, specifying the numbers, everything. Each PD can have a meeting with the advocate, then get a timeline how this can be uploaded. विनय वो आगे क्या? जुपिटस.
आप सभी PDs क्या है कि अपने साइट इंजीनियर्स को या आपके कोई लैंड एक्विजिशन के जो लोग हैं ना, उनको आप 1-2 दिन के लिए अपने एडवोकेट से बात करके जो जैसे एडवोकेट टाइम दे उनके ऑफिस भेज दीजिए. आप एक एडवोकेट को आप 2-3 दिन के लिए 1-2 आदमी दे दीजिए, टाई अप कर लीजिए, टाइमलाइन फिक्स कर लीजिए और फिर अपलोड करा दीजिए. ठीक है, उनको भी दिक्कत हो रही होगी, पुराने केसेस हैं, सारे डॉक्यूमेंट्स हैं, नहीं हैं, जहाँ भी हैं, ऐसा करके आप लोग कोशिश करिए within 2-3 weeks time. And if all these cases are uploaded, then you can inform me. I can send a proposal to headquarter for making some payment also 300 rupees per case, as has been done in the month of April and May. ठीक है ना?
Dayakar from Jupitis.
चलिए इसको हम कराते हैं within 2-3 weeks time.
So he is Dayakar. He has been engaged through Jupiter's, the firm which is managing this litigation management. So he will be stationed your office only. He will help to get all things done.
Okay. You are from?
From Jupiter's, which we have hired.
नहीं,
Jupiter's.
अभी your hometown. चलो ठीक है. He is from
He's
Guntur.
local person only.
And now he has been appointed as a legal
Otherwise, if you have only few columns regarding what happened in the last occasion, next adjournment will be there, what next result will be there. Just like that, it is easy. Because of lot of, it's a new portal, we are not in a position to adjust for that, for loading all the documents also.
Okay.
If the documents will be directed to received by the PIU. If PIU is loaded all the documents, remaining details very easy for us to load it and say what is happening.
Yeah, my PDs will also be helping you. All my advocates. I am asking my PDs to give 2-3 persons for 2-3 days to my advocates, and please sit together. Maybe Saturday, Sunday, Friday, whenever you have time, and please get it uploaded.
Thank you, sir. Thank you.
You are not able to? We have made two columns there actually. What is the claim amount and what is the award amount? There is two columns are there. What is, if we are litigating, if we are the petitioner, how much the amount we are agree with? At what rate we are agree? Then you have to enter on that. And what is the Kala award amount? You may enter in that amount. Any other thing is there?
Similarly, if the petitioner is the aggrieved party, then his claim amount.
What he is claiming to be entered on that portal. So why we are entering these data? We want to make a policy. We are going to frame a policy, or we are going to set a guideline for the authority who is going to accept the award or who is going to accept it, whatever the case is maybe. So for that we need some information. We need some information about how much enhancement amount people are seeking. What are the issues on which people are litigating? That's why we need this data. And it is not possible without your help. It is a collaborative effort from the advocate end, from the PIU end. Please upload the data, and as soon as possible, please complete it. Thank you. Any other issue?
कार्तिक, आपका इशू रिजॉल्व हो गया जो पेंडेंसी का था कि एडवोकेट का बिल कैसे पास
हुआ? Disposal status, sir. So as discussed, sir, in the any last year, yes, sir, they are saying any field you can complete it and you can show it as a disposal status, sir. So like that we'll do it, sir.
So you can explain to all PDs. Please explain this issue.
Yes, sir. So, sir, regarding this advocate bills, actually different hearing dates were there, sir. So accordingly, we need to fill the fee applicable. So suppose for old cases, if those dates were not entered in that sequence, then we may not be able to pay the fee. Suppose in our PIU login, if you go and suppose that case is disposed, if you go and dispose that case, then the advocates will not be able to again raise the bill that sequence wise, sir. What Vimal sir has suggested is, okay, for the time being, whatever is the last hearing or concluding date, at least one hearing date can be created and the entire amount can be loaded in that case. That need not enter the entire sequence of cases, case hearings, sir. So in that case, sir, we will create one date, hearing date, and then we will dispose it in PIU login, sir. With the help of that last created hearing date, they will be able to raise the bills.
So all PDs, please show all the cases which have been disposed of. It should be seen as a disposed of on the portal, because other PDs are having some apprehension that if we dispose of the cases on the portal, then I think we will not be able to make the payment to the advocate. But this is not the case. Even if it is shown as disposed of on the portal, you can make the payment to the advocates. So there is a difference, because headquarters is asking data, PDs are saying that some 1,000 cases are pending, whereas portal is saying some 6,000 cases are pending. So this should not be the case.
Sir, one doubt, sir.
Yeah, please.
Yeah, with respect to there is a win or loss. With respect to arbitration cases, for example, the claimant has claimed 1 lakh per square meter of his land.
arbitrator did not accept with the proposal, but he has enhanced it by 10 to 20%. So how we should construe it? Because what we have defended is there should not be any enhancement in that. But arbitrator did not accept the claimant proposal completely, to 1 lakh. Or, our proposal also he did not accept per se. He has enhanced the overall compensation to 10% or 20%. So how we should construe such a scenario?
So this is a win-win situation. Neither the claim of the... somebody else is going to say something? The arbitrator has not completely accept the claim. Yes.
Yes.
It is because of, it is partially allowed. No. Partially allowed. It means you have put your effort. You have put your effort, and you. Yeah. Okay. We will include that. We will include that.
No, my endeavor in, there are certain situations, even in High Court also, it is not always writ petition allowed or dismissed. They would be disposed of with certain directions also. This particular scenario needs to be accepted, and every such is not a loss per se. Even RO sir was saying that we are accepting 20 to 30% hike also with respect to arbitrator. Okay. So in my view, to some extent it should be construed as win. But how we are deciding at policy level, headquarters level is
that will be decided by RO and PD.
Yes,
the PD think that this is a...
The only issue.
You have won the case. It means you have won the case. Even
once we have not gone further in any appeal,
yes, sir.
That is win for us.
Okay.
Any case which we have not gone further appeal, that is win for us.
If RO is accepting the award, arbitration award, it means you have won the case.
Every case where we have accepted the decision of that court, that is win for us. So that has to be taken as that only.
Thank you, sir.
100% it cannot be. But if something has been done and we have not gone further in appeal, then we can take it as a win case.
Yes, sir. Thank you, sir.
Sir, one more issue, sir.
Kismurti? Yes.
Sir, regarding this...
Actually, win loss is something. Performance rating is something else. Yeah, definitely. It is 5-star rating. It's a 5-star rating. You can...
It is Chitur?
Sir, regarding the module for entering this drafting fees and miscellaneous charges, sir, I think that module is being developed.
See row number 2. The advocate won the case actually. Active case is 1, disposed of 1, and he win the case. Now what is the performance of advocate rate? What is the rating? You see negative rating here. It is not interlinked. The win-loss is not interlinked with the performance. Performance rating is something else. It is irrespective of win-loss. Although, while assigning the case, we also consider the number of cases win and loss, but the performance rating is something else. It might possible, in spite you have defended well in the court, but the decision came against us. Against us. In such situation, your performance not bad. Your performance too good. So a PD can rate on the basis of how you have handled the case in the court, not on the basis of how you win or you lose, if it is not the case. Somewhere advocates are not defending appropriately and we are losing the case. In such cases, I don't think PD will rate good enough. It is entirely different. No, it is not the mercy of the PD, sir. Actually, his question was, I have defended the case well in the court. I have defended the case well in the court. But the arbitrator or the judge has awarded against us. It is not my fault. I have defended well. My performance was well. But if you will rate me on the basis of win-lose, then what rank I will get? And then I explained it. It is something else. Performance rating is something else. It is overall performance. Your performance, how you how you defended the case in the court, it is here. How well you defended. You have taken the actual merit grounds. In hearing, you appeared appropriately. All thing was done, then this will be definitely positive side. You are seeing the example here, no? Somebody has okay, sir. Good suggestion. We can fix some parameters. Definitely we will include this.
Sorry to add one thing. There are some cases, old cases, particularly from
Welcome back, everyone. Now, I invite Sri R.K. Singh ji, CGM Technical and RO NHA Vijayawada, to please present his presentation.
ये ठीक है ना? बड़ा कर दो इसको. नहीं स्लाइड बड़ा कर दो ना.
You can just take this. I'll open the slides for you.
ये ठीक है. नहीं इसको बड़ा करो ना. इसकी जरूरत नहीं है.
हाँ ठीक.
इसी में हम. वो मैं कर लूँगा. वे कहाँ है? पेज है ना. हाँ बस इसमें फुल करो ना. Good afternoon to all. Actually, this is not presentation. This is a manthan. So we want to learn something from our advocates. We are a little bit confused in so many, maybe circulars interpretation or what challenges we are facing with arbitration or district courts. So how we have to proceed, how we can minimize our timing so that these cases are disposed of at an early date, and our lands are handed over to our concessionaires and roads are constructed for which we are here. So basically our aim is to provide facility to the public, for which we are fighting with several departments in the state government as well as central government, and also we are fighting with arbitration, with courts. So I thought it is a good opportunity for us to interact with our advocates. That's why headquarters has taken a good decision to involve advocates also, because advocates also one of the important link in this land acquisition process. So what we have felt, a limitation period, everybody knows, I think headquarters Mr. Chaturvedi DGM has also informed us that there is a Limitation Act 1963, and as per Article 137, limitation period is 3 years. So the cases which are not shown in the Limitation Act, for that default period is 3 years. So we hope that this period also applies to our land acquisition cases, and this has been clarified by Ministry also. So, but as a RO, I am getting such cases which are applications are being submitted by applicants after 5 years, after 7 years, and I think last week also I have dealt one case. I returned to the PD. Arbitrator has given award entertaining the application which was filed 5 or 6 years after Kala's award. So that is the cause of action, Kala's award. When Kala's award is declared, from that day within 3 years, if any party is aggrieved, whether NHI or PWD or farmers, they have to present their application before the arbitrator within the limitation period of 3 years. And if it is not within 3 years, simply our advocates would say, sir, it is over, it is beyond the limitation period, this application cannot be even entertained. Without listening this application, it should be dismissed. So any advocate can respond on this. They must be also facing such situations with the arbitration. Let us discuss freely. This is not a presentation, just we are doing some manthan. Yes, please. Anandji. Mic can be given to him.
Practically what is happening is in the recent judgments given by Apex Court, the date is not from the award, date is from the cause of action.
Okay.
So cause of action, how it is being interpreted is depending on the arbitrator. So what is taking into consideration is when this particular petitioners came to know about the award. Because as we all know that the award is not being circulated to the petitioners. So petitioner is applying through right to RTI. So that date is being taken as a cause of action date. From that date, the 3 years is being calculated. That is the reason why some of the cases are slipping between cup and lip.
Then when award is declared, then this award is given to PD or executive engineer PWD.
Exactly.
It is not shared with the farmers, what you are saying.
Yes, sir. So in principle, like...
No, Kalas is giving award. What he is saying, it is not being supplied to the, suppose it is farmer. If BR agreed party, no issue because it is being supplied to us. PD is submitting to RO for approval or for taking decision whether it has to be agreed or it has to be challenged. That may also be considered as a cause of action. Date of cause of action may be when the payment has been released to the party. Mic can be given to him. Any PD, any advocate, just we are having a manthan on it. And Manuji, you please note it down all the points so that we can take it up with the headquarters.
Approved. So either that date, because when that matter is known to the party, that this is the compensation determined by the Kala. Once he is aware from that, that is the date from which that 3 years period is to be counted.
Yeah, then we have to find out the ways how we can pursue with the Kalas to share the award with the farmers.
Sir, I am talking about the cases where the claimants who have not attended the 3G inquiry. Those are the specific claimants for which we are facing the problem. Because when they did not attend the 3G inquiry, they are taking it as an excuse saying that we are not aware of it. Because it's a public notice, maybe I have not gone to, I am not staying in that particular station. So I am not aware of that particular notice. So that is the excuse they are taking, being a beneficial legislation, even the arbitrator and the courts are considering that. So that was actually the observation by the apex court.
But 3G notice is before award declaration,
yes,
na? That is not point. Point is when award is being declared, even if they have received the 3G notice, they have attended the inquiry, but they have not been shared the arbitration award. Then they can say I have not been shared.
What they are saying is 3G notice. I did not receive any notice, and first time I came to know through my neighbor, or out of blue suddenly I came to know that my land is being acquired. So when I filed this RTI, through RTI I got the information. So consider this date bolke, they are telling, and the arbitrators are considering that date as a cause of action. From that date they are calculating that 3 years.
No sir, there is some issue. What he is missing is, when somebody is not attended to award inquiry, he is nowhere in the list. Unless he comes back to the Kala, providing his all the documents and get his title proved, then claim for the compensation, then only he has to approach the arbitrator. When he has not declared in the award as a person, he cannot go to the arbitrator. You have not provided in award inquiry any information, you are absent.
Okay.
So your name is not found because in the absence of documentary evidence or anything, the amount is kept in abeyance or something, it is written by the Kala. In such cases, nobody has a right to go to the arbitrator that I am owner of this particular piece of land unless until he proves before the Kala that I am the owner of this land and I am eligible for compensation. So that is the case. Otherwise, there is no such cases. We don't have such cases. The people where they are going to arbitrator without finding their name in the award.
Okay. No, but still we can think of how it is to be shared with the all parties.
Sir, in the RFCLR Act, there is 1 page award, is individual award intimation. That if we can adapt that in one page is name, extent, acquired and compensation awarded. That will be given. Instead of giving this much of book, they used to give the 1 page of the award copy for individual copy.
And if they require, they can take a full copy?
Yes, sir. A copy can
that
be
is also
supplied
one of the issues. So we have to take action.
Yes.
My PDs have to inform the Kalas, or I can also write a letter to all collectors and Kalas.
Yes.
So that to avoid such situation in the future.
Sir, once compensation is deposited, sir, Once NHA deposits the compensation, sir, in Chittoor district especially, they are issuing the Form C notice, sir, which is similar to 3E notice, sir, that this much amount is awarded to you, please come and collect, sir. So that notice immediately, once the NHA deposits, sir, that notice if it is issued, sir, that can be taken as a cut-off date, sir. That is a
You
better
please
option.
share that notice to us.
We are having
The
that
problem
notice.
is that Kartigar, we are doing Bhoomi Rashi portal payment. Now only the PD of Scala office is taking the bank account number, everything they are feeding. So not knowing the award is, it is not possible at all because he is giving his bank account everything at the time of award inquiry. We are feeding it in Bhoomi Rashi portal, his bank account, everything. It is going and directly is getting money.
No, sir. At award inquiry, that is not happening, sir. After passing the award, sir, we are actually approaching and collecting those details, sir.
Okay.
Sir, actually, Bhoomi Rashi is meant that at the 3G stage or 3D stage itself, we have to upload all those documents. But that is not happening, sir. So, at least after the passage of award, sir, if that notice is issued, we can, at least that notice should be taken as a reckoning date, sir. For
Okay. Which notice?
That whatever 3 notice which we give it, sir.
The 3 notice is different thing. 3 notice is taking possession or surrendering the land. No, Swain Saab, before notice, you are already depositing the money to their account. After depositing the money, only you can give this notice, 3E notice. 3E1 and 3E2, 3E1 after depositing the money in their account, and 3E2 after 60 days.
There is a bit of sequencing problem here, NHA. This 3G, 3G happens before your 3H and 3E. 3G happens.
Yes, correct. Yes.
So once your 3G has happened, you are immediately supposed to give a notice to at important places. You are supposed to publish that notice, giving them 60 days time to come and give their details and surrender their
hand over the position.
So
Without making payment? Without making payment, can we say?
You are making payment. Say that's why you have given the 60 days. So within this 60 days, you are making your, that's a 3H and a 3E. So immediately after 60 days, you can go for your.
Okay, means you are saying after 3G, we are also issuing 3G notice. 3G notice, inquiry notice.
There is 2 pages. These are the 2 notices which you are supposed to issue. It is part of the guideline.
But in this notice, I think there is the amount. What amount we are giving to them? Amount is not there in this notice, na?
No, sir. It gives a general abstract, sir.
No amount is
Actually, Kala is giving a individual 3 kind of Form C. Is a local name is Form C, sir. Form C, may all details are there, sir. So that Form C, everybody comes to know through Tahsildar. It will be circulated, sir. So better to take that notice as a 3 years period.
You please share
Yes,
with
I'll
me.
share it, sir.
You share
Yes,
with me Form C. We will study and
Yes,
then
sir.
take a decision.
Sir, Act requires
Maybe you are acquiring part of the survey number.
Sir, as per by act, Kala is obligatory to share the award to
Bas,
the each.
that's all. We have to share the award. That's all. उसका कोई वो इसका कोई substitute नहीं है. What I think. In
legal.
award there is everything. If suppose I am landowner, I am RO, I know all the things. But you are not sharing me. You are saying I am taking over this land and you are giving you 10 lakh rupees. For what 10 lakh rupees? What nature of land you have considered? How you have arrived the rate? So all these things are discussed in the award. So then they have a grievance and then they can go to the arbitrator. Anyway, Anandji, you have explained it nicely. So we have noted all the points and again we will discuss. I want to hold a meeting with our advocates also. Okay. In January I have held first meeting and then we could not get time for the second meeting. So I will study all these points, then again we'll discuss with you people, then I will take it up with the headquarter. And whatever is required, I will write a letter to all Kalas and collectors to take such actions so that these limitation period cases can be avoided in the future.
But sir, there is one court case, sir, I think our order has been given to Amravati court itself, sir. In that it says that 3 notice is not mandatory. That it is written as may, so it is not mandatory, unlike 3C. 3C.
That is not an issue.
So, sir, but for considering this limitation,
three notice is only 60 days period. We should go with 3D notice, whether it is mandatory or not. That may be additional thing because our manual is saying.
Sir, why 3 notice? I will tell why 3 notice. Because without depositing the compensation amount, one should not take possession of the land. In general act. But in NH Act, by informing the people, 60 days we are giving time to hand over the position.
And take the amount also.
Receiving the amount.
Yes.
That is fulfilling the legal provision that we have already informed. But we don't have such facility like regular act to deposit in the court. But it is with the Kala or the amount is ready, then you are supposed to come and take. If you failed it, means that we have fulfilled the legal provision, we can take possession of land if he doesn't deliver the position.
So, but that 3 notice is for entire village, sir. You will only publish the name of the village, amount of the award only. But individual notices, that is not there in the act. 3-1, even 3-2 also.
No, in a single notice also you can write so many names and it can be served to all.
What we are
Our individual notices can be done. That is not an issue.
3 notice, actually I contested the matter. 3 notice is not at all mandatory. 3 says may issue a notice and take the possession of within 60 days. So the 3 notice is not mandatory. If any person is resisting for delivery of possession, then 3 notice will come into operation. 3 notice will not be clubbed into the awarded amount of compensation. It is no way related
that is
to the
correct.
award.
You are correct because 3 notice is related with the taking possession of the land.
That's all.
That is not informing the award or other things.
Nothing
That's why I am saying award has to be shared with the landowners. That's all.
The award, the passing of the award should be in a conspicuous place, noting this award is passed by Kala with regard to so and so village, so that villagers knows about the passing of the award. If anyone wants to see the award, they can approach the Kala for taking award.
Yes. This is a principle of natural justice. If you have given authority to them to challenge the award, then they has to be supplied the award. Otherwise, how they will challenge it? So, by any means, we have to give it to them. That is the only solution, I think. Second point is obtaining and verification of supporting documents filed by the petitioners at the time of filing of arbitration. I think here also, situation is, I am sorry to say, very pathetic. Why? I don't know how arbitrators are holding the meetings. Sometimes, if I am talking to my PDs, they are saying, I have never attended this arbitration meeting. Or none of their advocate has attended this meeting. Arbitrators, without giving any notice, if arbitrators is a quasi-judicial body, he is acting like a judge. So, you have to give the notice. It is the natural justice. You have to give the notice to both the parties. You have to give the time both the parties. Then you will hear, fix a date. You will hear both the parties. Based on the argument, decision is given. Arbitrator, judge and district court or high court, supreme court, they are not going as per their thinking or their consideration of the things or their understanding. They are going only by the arguments being given by the advocates. That's why sometimes we say good advocates is winning the case, bad advocate is losing the case. So we have to argue before the arbitrators. So once any party or arbitrator is giving the, immediately we have to resist it. We have not been given chance of hearing. And all my advocates are aware that in so many cases we are getting stay orders because 3C process has not been completed. 3C notice has not been given to the farmers. They have not been heard. Even they have not been supplied the decision taken by the Kala on their grievances or on their applications. So this has to be enforced. So we have to tell the collector, whenever any arbitration application is being given to them, they have to inform the PD or executive engineer, whoever is the other party, so that we can also file our counter. My advocate can attend the meeting, argument should take place, and then this should be given. So anyone, any advocate or any PD?
Sir, in this contest, the arbitrators are accepting Mahajar petition. But by law, they should accept only individual petition of the arbitration petition filed by the landowner. Instead of that, one big petition with all the signatures, like some sort of material written and a thumb impression, and they are filing. In Anantapur, they have done it. They have considered it as arbitration petition, they filed, but they have not supplied to the PD, they have not, there is no argument. That's why we must obtain the copy of the petition filed by the arbitrator, and then we file the counter affidavit basing on the what are the contents of the petition and the documents filed by them. In many cases, no supporting document is being filed by the landowner. Simply they are demanding this much, and the arbitrator accepts.
Without any supporting document.
Yes. So that
without any ground, without any reasoning in support of their demands, instead of 5 lakhs per acre, they are asking we should be given 15 lakh per acre. We should be given 20 lakh per acre. But that must be supported. Otherwise, how arbitrator can take a decision? And then we are also following some counters, or we are also arguing against this 15-20 lakh rate. Still, arbitrators are not listening us. So that is the issue. We have to think of it, and we have to educate the collectors also. In future, at least they should give us or supply documents to us, because we are also a party. You have to hear both the parties, and then please take a decision. Yes. Yes. Yes, yes. Yes, yes, yes.
That's why second para.
Actually, collector is also not having a separate office for this. Just he is acting as a district magistrate and collector, and he has been given another responsibility of, like I am this अभी यहाँ पे अपना विशाखापट्टनम में एक कंपनी है, विशाखापट्टनम पोर्ट रोड कंपनी. I am MD of that company. I have no person. Even in the name of BPRCL, I don't have any PA also, any steno, nothing. Certainly, every week some paper are coming from the headquarters. You please sign it. तो ऐसे ही कलेक्टर का भी है हाल है. कलेक्टर तो डिस्ट्रिक्ट कलेक्टर मजिस्ट्रेट है. ही इज हैविंग सम पर्सन्स वर्किंग अंडर हिम. ही हैज सम सपोर्ट स्टाफ. सो दैट इज फॉर द डिफरेंट वर्क. दैट इज नॉट फॉर द आर्बिट्रेटर वर्क. तो उनको भी नहीं पता है. acting under district collector. So they are independent. Arbitrator has to rely upon the submissions made by both the parties. That's all. This is not the job of arbitrator to take any report from Kala, to take any report from Tehsildar. Whatever parties are submitting, based on those documents, based on those arguments, only he has to deliver the judgment. That's all. Yes, Kala is also a party. Kala is also a party because, yes, yes, yes. He cannot give any report to the collector or arbitrator. Yes. So I want to ask from my advocates, is it admissible as per law? Can arbitrator ask any report from Kala or from Tehsildar? No, as a special case, if he is calling, that is okay. But why on daily basis he can call report? He is a judge. He is a judge. He has to rely upon the submission made by both the parties. No. It is not his job. It is not his job. He is not redetermining. He is hearing a case. A party has submitted a case. Suppose if you are going to the High Court, what judge is doing? He is listening you. He is listening other party. Whatever counter you have submitted, whatever counter he has submitted, based on those things. Judge is not asking any report from anyone. He can ask, but not in all cases. Not in all cases, na. As a special case, if any issue is complicated issue, then he can take. Certainly he can take, but not as a regular matter. So that is my point. What you feel? What my advocates feel? Otherwise, we can also oppose this before arbitrator. Why they are asking for report from Tehsildar? Why they are asking for report from the Kala? Kala has given a word. Against Kala's award, this application has come to the arbitration.
No, arbitrators are writing directly as per report of the Tehsildar.
As per Tehsildar report, as per even Kala report. He is again taking the Kala's report. So all Kala's award is being vetted by the arbitrators. So अभी इसमें आ रहा था ना, what is the performance of advocate? So in all arbitration cases we are losing. It means all our advocates are bad. February 20.
Time limit is 60 days.
Yes.
Statutory law provisions prevails the rules, GO, whatever GO or rule something. But the law clearly tells that paying challan fee is enough to consider it as a conversion. So let us park this point apart, sir. We can have a discussion, detailed discussion on this, because I have a documentary evidence. I have some material on that. I have done some.
I will supply you both GMS.
Yes,
This
sir.
both GMS I will supply you. I have given to Mr. Yogesh.
Sir, ultimately statute prevails, not the GO. When there is a conflict between a GO or a rule and a statutory provision will prevail. That is actually
what is statutory provision?
That simple paying chalana fee is enough to consider it as a conversion. There is a straightaway statutory provision to that. What Yogesh said is right. That particular.
Okay, no issue. We will discuss with the next meeting. Next meeting with the advocates. You please study.
Sir, I have
we will discuss.
Anytime I will bring the materials.
Okay, Anand Garu, as long as it is said by the court that your GO is not valid, the statute therefore is till such time the GO prevails.
I don't want to debate it, but there is
okay,
a city law.
we'll discuss
it.
in
Law that
no problem.
Always a statutory provision prevails over GO.
Okay, of course.
No,
when it
this
goes
is
to court.
this GO. This is a rules.
Yes, sir.
This is the rules. Rules has been made under some powers given to the government.
When the statutory provision is not amended, ultimately that stands good when there is a conflict between a statutory provision and a rule or a GO.
Okay, no issue. If this is the case, then we will take up with the state government. They will change it.
Yes, sir.
They will change it for future.
Entire act is nullified
now
now.
the
sir.
act is no more.
Act
sir.
is no more now.
That act is
now,
not there.
I mean, last week they have nullified the entire act.
Now
Okay.
It's not in
Now
force.
there is no more conversion, non-agriculture and conversion act in
Okay.
Andhra Pradesh.
Andhra Pradesh.
If any, now our problem has been solved.
No, this then the GO still holds good or not?
The
These
whole,
GOs.
okay, sir. Now that they have given
As
the
on-
ordinance.
As on today, no. I mean, but the awards that are passed earlier, then we have to definitely consider this as Anand sir was saying. We can have subsequent debate on this particular issue.
No, so, means
As
then
from today, no.
how conversion will be done in future?
No, they
Future
say
it
that
goes to
some-
the urban bodies, sir.
Okay.
Urban local bodies, they have to approach with conversion as well as layout, everything. Now they approve with the order, even the director of town planning or the urban bodies, urban local bodies.
paying
like
the
urban
development
development
No, but urban local bodies is not having jurisdiction in the some areas. They are having only in urban areas.
Director
Jurisdiction.
town planning, approval authority.
Director town planning is having whole district
The whole district,
jurisdiction.
all entire area.
DTC
But in rural areas, is Buda. Buda is there, sir.
So they will do the conversion.
They will do
So there will be some other act.
Other procedure.
There
Other
is-
procedure, other act.
Yes, sir. They will clubbed with the other act.
Hmm.
Not only conversion they don't do. They will clubbed with the approval of the layout, approval of
Oh,
the
ठीक है. वो तो देखो, system is placed. This act has been removed. Now some other act will come.
more clear.
Conversion has to be done.
Yes.
Conversion तो होगा नहीं होगा. Conversion तो होगा.
They will take the fees in different ways.
So the second aspect in this particular thing
Ah.
I would like to emphasize is, as I was explaining, even if it is a converted and it is underdeveloped, then we have to deduct 40 to 60% as per the Supreme Court judgment. That particular aspect is not at all concerned
coming
by
up.
any of
अभी
the
है
kalas.
आगे है. अभी I'm coming to that.
Sir,
That we are enforcing. Kalas are agreeing.
so probably we need to give.
नहीं, Kalas are changing their reward.
Oh,
When I am returning back, they are changing it. No issue. ये तो वही हो गया.
Non-physical convert.
हैं?
Physically not converting and just
हो
simply.
गया. Same issue I think. ना?
Same. Now this is.
Counsels to get Honorable Supreme Court judgment implemented in the orders what Mr. Yogesh was asking, passed by arbitrator for deduction of 1/3 awarded amount. So Kalas are taking it as a house site. House site. Of house site, there may be so many types of house sites. One house site is Vijayawada. Everything, we are sitting here in this hotel, everything is developed, roads earmarked, water tanks, parks, all amenities. And if you go 5 kilometers beyond, that is also house site. Layout has been finalized. No roads earmarked, no water tank, no parks, no amenities. Still they are loading the same rate of house site. What is rate of this hotel per square yard or per square meter? But that's why we are saying it has to be deducted 1/3. Why? Because you are loading total area. You are not dedicating the area for parks, for roads, for amenities. So that is also costing. For that we are not giving any compensation. That is being a public type of thing. So that's why we are enforcing it.
It is not 1/3, sir. As per the layout plan rules of Andhra Pradesh, 35% of the land should be reserved for roads, 10% should be reserved for open spaces. So the saleable land comes to only 45%. I mean, excluding 35 plus 10, 45. So saleable land only 55%. And now even in the saleable land, there should be some development charge. For example, they have to lay a road, they have to drainage, electricity, all these things. So this particular development charge would be, I mean, anywhere between 5 to 15%, depends on the nature of the present day land.
Correct.
So therefore, minimum the deduction should be 45%, and it should go up to 60% based on the nature of the land. Supreme Court also stated clearly, I have mentioned
Yes,
that.
correct.
Yes, sir.
No,
So
we also know all these things,
Yes,
but we are making the procedure very simple.
Yes, sir.
Please at least deduct 1/3. Let it go to the farmers. No, they are poor people, let them go. But we cannot give 100 rupees.
Yes, sir.
But happily we will give 66 rupees or 67 rupees. That's why I am time and again saying, if you feel that the rates have not been revised, guidance value or circle rates or basic values, you please give 20 to 30% extra in the name of section 28, at least natural justice. So some parameters given, some discretionary power given to the Kalas. You please apply, you please use those powers. Simply you cannot say this is agricultural land. You are saying that I have visited the site and I feel like house site. I feel like fit for house site. It is not our whims and fancies. ऐसे नहीं होता है. Government में तो we have to have some documentary evidence. So or at least you put something where powers have been given to you. Then we will agree to 30%, 20%. Why 30%? I am talking about total amount. Suppose 100 is basic value. 1.25 factors, solatium, interest, maybe 250 to 56 rupees. 30% comes to 75% or 8%, 75 or 80%. Means 75 rupees, 30%. Means 100 ka 75. So any damage cannot be more than the basic value of the property. So basic value of the property is 100 rupees. Whereas we are giving 250 rupees, factor and solatium. Then 5-6 rupees interest, maybe 256 rupees, 260 rupees, maybe 270 rupees. So 30% आप ले लो, 75%, 80%. 75, 80 rupees आता है. 80 rupees means 80% of 100. If you go more, then we cannot give more than. So what maximum I have agreed, and this was agreed by CCLA also at that time. Mr. Sai Prasad was CCLA. I was presenting the same before Kalas. Not 20%. Why not 10%? So there must be some logic. He immediately agreed. He instructed all Kalas. You use this if you feel rates are less. We don't, in genuine rates, I am very liberal officer. So as long as we feel that it is a genuine rates, we don't have any issue. Because if suppose if my land is there, if I am selling you, I am getting 100 rupees, why I will take only 50 rupees or 60 rupees from the government? So naturally anybody will protest. So, and also it is a very complex matter. आप जितना डिटेल में जाओगे उतना ही इसमें issues आएंगे. Even still we are not able to understand all the things.
The issue would be tomorrow they will challenge a reduction of 1/3. But if we go,
all are agreeing. No, all these issues have been settled.
We will have a legal backup if we go with the rules of layout rules in Andhra. So which mandates?
That is not possible. That is not possible. Then you have to take who is competent, who will rely upon my working. I have worked it out. Who will rely upon it? Collector will not rely. Arbitrator will not rely upon your report. I am a party. So he will say, you just go to some architect, go some civil engineer, some valuator, you take report. Who will go in those details? That may be 40%, that may be 60%. But I am not worried about 10 to 15%. Let it go. No issue.
We have implemented in many cases 1/3. Then whatever we have, when we insisted, then they.
We have returned such awards to Kalas, and all Kalas have directed this. Yes. They are agreeing. That is not an issue. They are also agreeing to it. If anything is logical, they are agreeing. Some of the arbitrators are upholding the action of the Kalas in awarding the compensation, basing on the future potential of the land. Our manual clearly says, whatever is the land whatever is the subject land, we have to see that land only. Because here we are sitting, this is a commercial land, side land may be agricultural land also. So it's not that. In a one survey number, part land may be commercial, part land may be residential, part land may be agricultural also, may be fit for house site also. So whatever is the land, you have to take that nature of land and you have to give the award accordingly. And if farmers or landowners having any regions, any grounds, they can go to the arbitrator. Let them go. They have some course of action. Remedial measures given in the act. Let them go. This is also one of the issue. I don't know whether argument is taking place or not. Even if it is taking place, that is not being recorded. Sometimes I am seeing in high courts also. My advocates are telling me, sir, I have spoken like this, like that, like that. But that is not being seen in the judgment delivered by the honorable judges. So we have to force the Kala or arbitrator, please write all these things. Or the best way is, we have to submit our counters. We need not to say anything. We have to give something in writing, all thing in writing. That will be on the records. Tomorrow we can place before any authority. We can say that we have given it to arbitrators, they have not taken it in the record. Is there any provision for filing expeditious petitions before the arbitrator, like in high courts? Anand ji?
Even high courts
कुछ
also.
बोलिए, मैं अकेले बोल रहा हूँ, कहाँ तक बोलूँगा मैं अकेले?
Sir, even in high courts also.
सबने लंच लिया है, सबने खाना खाया है.
Sir,
कुछ
even in
बोलिए.
high courts also, expeditious petitions are like, it's mentioning only, it's not a petition filing, just mentioning it before the justice, honorable justice, to consider it being, keeping in view of the agency where the road work is installed. Ultimately, it is the discretion of the honorable justice to consider it or not. The stock answer by the justice is like, always all the matters which are in front of me are urgency matters. So it is always like depending on judge to judge, they may consider, they may not consider. But our efforts will be there for expeditious petitions, maybe in a manner of mentioning.
And we are also assessing the performance of the advocates. So these are the issues. When we don't have any data, how a decision can be taken? I have also asked my all PDs, please study all arbitration cases. What are the issues? Like nature of land, or some enhancement, some justified things, or unjustified things. What are the implications? Suppose implications 1 lakh, 2 lakh, we will agree, no issue. So we will send it to headquarter one time relaxation. Headquarter will also agree because headquarter is also in mood to reduce these pendencies.
Sir, small correction. It's not the delay happening after referring to an advocate. If it is brought to the notice of an advocate about a petition, the arbitrators are completing. That stage is smooth. Like that petition getting a notice and appearing in front of the arbitrator and passing an order. 90% the process is smooth in that level. The delay is happening from the time of the claimant putting an application before that arbitrator and arbitrator taking up that case. So when the arbitrator took up that case, that time like an advocate is being involved. In that meanwhile, like advocate is not being involved.
When arbitration petition has been filed, so it is supplied to PD. Suppose I assume it has been supplied to PD. Then PD has appointed a advocate.
No, it's small, sir. When a claimant puts an application in front of the arbitrator, at that time it is not being served to the PD, sir. I'll tell an example. Nellore, like last week, I was there at the
that is not my issue. My issue is simple. When arbitration application has been filed, it has been given to PD. PD has appointed an advocate. Now let us suppose after 2-3 months hearing should start. So arbitrator should hold hearings. It has to be completed within 6 months time.
Yeah, that process is smooth, sir. Like the delay is happening between the application filing time and the arbitrator taking up the case or serving the copy to the PD, sir. That during that period it is getting delayed.
No, if case is pending more than 10 years, 5 years, so then what are you saying? It means these cases have not been given to PDs or no notices have been issued by the arbitrator?
Exactly, sir.
So all these data we know, we want to know.
Yeah, we will know.
Please help us. Please help us where these arbitration petitions are pending. What is the stage? What is the reason? What they are asking? Otherwise we will say to the arbitrator, sir, please you give this judgment. I will agree. What petitioner are asking?
Last week we had I had a discussion with District Collector Nellore. The same thing happened. Like the applications were made in the year 2016 and 18. 2016 and 18, and the cases are being taken up today. So I told that, sir, unnecessarily we are paying the penalty, like we are paying interest for this delay. Then he agreed, yes, that our officers are somewhat like because of some loopholes, like they got delayed. From here onwards, like I will take care of that. And he asked the subordinates, and they told us about more than 50 cases are there pending in the Nellore case. Then he immediately ordered to bring up all the cases for hearing.
So that is we have to, I appreciate your efforts. So we have to make an effort. And also I am requesting all my PDs as well as advocates, please have a meeting together and please analyze what is the stage and what is the reason. Certainly that is enhancement case. So what are the reason? Why they are asking for enhancement? What is the cost implication? If it is very less, we can agree. All these cases will be disposed of in a single hearing. And we will agree to what petitioners are asking. There may be 10-20% such cases. So that my headquarter also wants. So, and we can again discuss. I will also be party to that discussion. So we can work out some via media, some methodology, some principles, how we can agree to these cases. Then I can request my headquarter, sir, these are the issues. There are 6,000 cases. Out of these 1,000 cases having implication only 50, 60, 70 crore rupees. Individual cases maybe 1 lakh, 2 lakh, 10 lakh rupees. You please give orders so that we can close these cases. Happily headquarter will agree. But we have to hard work. We have to analyze these things. We have to summarize it. And then we have to discuss and finalize it. That is my request to my PDs as well as my advocates.
Okay.
Delay in filing AOP cases. I don't want to take the name of PIO. 11, 12 cases that was not filed in district court. Then we went, I discussed with my advisor. I was also worried. Then somehow I discussed with advocate and decided to go to the High Court. I didn't get any relief from the High Court also. ultimately that was dismissed, and ना चाहते हुए भी मुझको agree होना पड़ा. So it is a request, my request to all PDs, please be sincere, be proactive, and be vigilant also. I am not saying your team is not doing good job. Your team is doing good job. But you have to monitor. You have to supervise the things. You have to know what is the case, where is the case, are we taking action or not. Like for example, I am asking my PDs, what is the PCC date? Please tell me what is provisional completion date. Before 1 month or 3 weeks or 1.5 months before, RO has to inspect the site. Without RO's inspection, PCC cannot be issued. So sometimes I am also worried. Sometimes PDs are calling me, sir, ये तो PCC होने वाला है. कब होने वाला है, sir? बस after 3 days. In some cases, sir, 1 week before we have decided. If RO is going to the site and RO is having some observations, then that has to be complied by the contractor and concessionaires. And without that compliance, PCC date cannot be finalized. So we are delaying the process. So we are not here to delay the process. If the work is completed, contractor has done the job, he must be given the same PCC date what he deserves. That's why I am always asking my PDs, please fill in this Google spreadsheet. What is your assessment of PCC date? So that I can plan for a site inspection. Similarly, you can also ask your team, what is the case? Where is the case? How many cases? What is the situation? What is the position? What is the issue? You are having your team. And I have given liberally the team, and I have fought with my headquarter also. Finally, headquarter also agreed. Then I have restored my old team. And if you still have some less staff, please tell me. Again, I will request headquarter. But please do something. Now we have to work it out within a month's time. We have to finalize it and let us do hard work. How to reduce all these cases. At least if we do hard work a month time, I think our cases will be reduced, and I am fully confident it must be reduced to at least 50%. Yes.
Probably in data lake, we can initiate a trigger, particularly for execution petitions and filing AOPs. We can have a trigger in data lake. So once you close it, immediately the trigger should go to RO sir and PD sir and if possible headquarters, so that the 90 days time can be ticked down and it can be reminded frequently, because 120 days after that, I mean, there is no way, particularly in arbitration, even there is no extension of that also. Even 90 days is the limit and 30 days is the extension. So this way we can actually integrate with the data lake. So once they trigger it, and the trigger should be monitored regularly, because even it comes to your, I mean, RO notice very at belated stage. Even sometimes I get a 1 week's time to file AOP. So though 90 days time actually from the date of passing of the award. So we can actually have a conversation with the data lake team. So that
आप देख लीजिएगा कुछ एक करें अगर facilities we can in the otherwise we are filling all these data.
Yes, sir.
That is there. So what my chairman is saying nowadays,
sir,
he is holding every week Saturday 7 o'clock, 7:30, and that goes up to 9 o'clock. 1.5 hour regular weekly WhatsApp quick call, video call with all ROs. And so he is asking 2-3 ROs, are you going through the dashboard or not? In Data Lake also we have a dashboard. So now I have also started it from the last 2-3 days. So there are so many things. And RO is having a data lake, dashboard. How many means about road condition, about dams report, EDAR report, EOT, CUS cases, what is the pendency, BIP references, how many pendencies. So if there is no trigger point, still PDs can see it. Everything is available on data lake. So it is our responsibility. That is, in a week, you will require only 1 hour. Any PD will require, and I think you also have access to the, my advocates have also access to the this system.
In this, the challenge is, even if some other work is not taken within the time, there would not be major impact. But once we are not taking up this within 90 days, then there is a major impact with respect to the, filing of AOP. So they should be given a priority over other triggers, even if there is a trigger mechanism. So my endeavor in submitting
triggers, of course, I am agreeing with you.
The issue in trigger is, first thing, you are uploading, immediately you are not uploading. The decision you will upload after 50 days, 30 days when you are raising bill. Then trigger is no use. Plus, the decision to challenge is not there.
Yes, sir.
So what is the use of trigger?
Sir,
Trigger can be activated only once the decision has been taken to challenge that award. So when the decision would be taken, that is not on data lake.
with respect to arbitration
What he
awards-
is saying,
Yes, sir.
first you have to fill in the data in the portal. Once you are filling the data in portal, if as an advocate you are filling, or if as a PD you are filling, then you know all the things. If advocate is filling, PD is knowing. PD is filling, advocate should know.
With respect to arbitration, the challenge is, sir. We have to
yes.
say something. I mean, with respect to arbitrations, the challenge is that the award is submitted only to Kalas, PDs, not to the advocates who are appearing in the case. So advocates will not be aware whether a particular case is disposed or not, in particularly with respect to arbitration. In High Court case and AOP case, advocate come to know of it when the particular case is disposed. This is a case where after reserving the judgments, arbitrators will not send any notice to advocates. They'll send the final awards to PD offices. So PDs will have the first-hand information with respect, and cause of action starts from that day when we have received the award copy from the collector. So on that day itself, we can have a mechanism to issue the triggers, because this is very crucial aspect. I mean, with respect to the
No.
timelines.
Issue is how trigger will come. First, you have to enter the data into the portal.
Yes, sir.
Once you have entered the data in the portal and dates, this is the date of cause of action. Now, within these 3 months' time or 4 months' time, you have to go to file EOP in the district court. So, once you are entering the data, you know all the things. No trigger is required.
Yes, sir. Here
But the issue is you are not knowing.
Yes, sir.
This arbitration award has been declared. That has come to PD office.
PD
I don't know whether advocate is knowing it or not.
No, sir.
Or PD is knowing it or not, but it has come. PD has marked it to its LA team and it is pending. So when PD is marking it, then he can note it down. Or he can tell some person, please note it down, this is important case. Yesterday you are saying, sir, I am having some case, I will not come to attend the, you were saying. So everybody is overstressed. You have to make a priority.
Yes,
I am also overstressed. Today it is my priority. I am not taking calls from headquarters even. Just chairman has called me, I have taken that and my member called.
Other thing is, a decision has to be taken whether the award has to be challenged. Decision only after 90 days.
That is the issue.
Yeah, we need to have a mechanism linked to data lake is my endeavor in submitting this, sir, because this is a time sensitive.
Data lake already has a mechanism to trigger alerts. But the date has to be filled up somewhere. No?
Yes, sir.
Who will take a decision? The awards are not processed on data lake. That is separately processed, not entered.
Because all cases there is no impact even if there is a delay of 6 months or something. But here this.
How we can ensure it?
Yes,
Are
sir.
any district advocates are there also there?
Oh,
How we can ensure it? How we can get as early as possible the award if it is declared by collector? Now I am discussing district court cases. So first issue we are facing, this is that 90 days
For that to
time
happen,
gone.
you have to immediately file the decision of arbitration on that portal first, and the decision to whether to challenge it or not. That has to be taken within that limited time. Then only we can take a decision.
Sir, a small submission. Important, sir. Sir, these are 2-3 important points, sir. First thing is, then they need a proper SOP, sir.
Mic pass में रखिए ना?
Sir, sir. How to
Pass में रखिए.
Sir.
Yes.
How to receive it, receiving mechanism, sir. Because it must be properly registered, sir. The date of receipt is important, we are saying, sir. How it is resembled in a proper way. That must be clarified, sir. One thing, sir. Next thing is, whether PD can take a decision at his level, whether to send to RO for decision or not. If you say it is a...
PD is not competent.
No, sir, no, sir. If it is a 50,000 more in arbitration.
That is not issue, na? RO is competent. You have to send the thing.
Every award to...
RO can
Timeline can be discussed in respect of, let's say today PIU is receiving the arbitration award. So from today, let's say the PIU has, because there are certain steps before we file the final petition. First, legal opinion has to be taken. Then the legal opinion is sent to the PIU. It's forwarded to the RO. RO has to take the final decision. Approval order is received by the PIU. It is sent to the advocate. Advocate prepares the petition. Then we file it in the court. So these 4-5 steps are there. So a timeline can be prepared that out of 90 days, 10 days are given for this particular step, then roughly 10 days are given for this particular step, and in the end, roughly 10 to 20 days
LCR not available, land records. So when we file the case, then the judges are waiting for the land records to come from the revenue department. That is taking its own sweet time. There we have a very limited interference. We cannot interfere into that because it is between the court and it will between the revenue departments. They both will coordinate. They both need to coordinate and get the LCR, lower court records to reach the judge. Only after that, the judges are listening. That is the another reason. The other reason is there peculiarly like depending on the judge. Some judges it's getting delayed basing on their own priorities. Like arbitration, it happened in Anantapur very recently, because she is not well versed with the arbitration law. She is postponing it.
Okay.
So when I insisted after a long time, after repeated visits, then she first asked me to present to the court and explain her the Arbitration Act.
Okay.
And then how it is related to the present issue. Like that, they are education levels of the judge, which is not in our hands. So fortunately, that judge opened it out. Some judges will not open it out and they will just postpone it. So these are the main reasons. Otherwise, whichever reasons in our hands, like filing the petition, filing the counters, then that will expedite, which are where we can expedite. But the other reasons where we cannot, where our interference is less, where our opportunity of expedition is lesser, there the cases are getting delayed.
Okay, thank you. Any other advocate?
Appear on behalf of district collector or state government being respondent, sir. So he is not at all attending, sir.
देखो ऐसा है, जब state as long as state government is required, उसको हम लोग को pursue
Yes, sir.
करना
That
है.
also we are doing,
देखो
sir.
it is our responsibility because road is ours.
Yes, sir. Yes,
We are constructing the roads, we are facing the issues, and we are answerable to the public also. You are getting so many WhatsApp media complaints. Sometimes
I am telling that reason, sir. Even for GP also, we are just following up and we are helping him also, sir.
Yes.
But despite sometimes he is not attending, sir, and this record doesn't go. So this is causing repeated adjournment, sir. And if the judge is good, sometimes he is saying ex parte, I am reserving the order, sir. Once after reserving for order also, sir, again it is taking 2-3 months, 3-4 months time, sir. So these may be the reasons, sir.
Our person should go and see that record.
Yes, that's why I am saying it is our responsibility. We have to act as a kala, we have to act as a revenue officer. Then it will be done, otherwise it will not be done. We cannot remain dependent on them. फिर कुछ नहीं होगा. उनको कोई, this is not their job. It is our job. ऐसा समझिए आप. Then you will be successful.
So for the district collector, we can give 1 or 2 staff, sir, exclusively to look after all these cases, hearing, then filing all these things. We can give, provide a supporting staff to the district collector to look after only this arbitration cases disposal.
Although you can take supporting staff, you can give your requirement. I can talk with headquarters. I can request headquarters. Then we can give it to Kala.
There is already a provision is there to provide facilities to arbitrator.
We will deduct from the administrative charges.
Administrative charges. There already a provision is.
Who is competent? RO can.
RO is competent to provide facilities to arbitrators. There is already a provision.
Yes, we
the
have the
whole
guideline.
issue.
तो इसको कर लेते हैं, इसमें क्या issue है?
We are examining.
You all PDs can give your requirement.
Yes, sir.
where monthly we should see what is the status of any case, why there is pendency, whether we have filed our counter or not. Because recently when we have issued this circular, now MV Kini is saying we have filed the petitions in 13,000 arbitration cases. Now, that means till now they have not filed the arbitration cases, counter affidavits or petitions we have not filed. So this is the status of our case. Once we monitor it, automatically that cases would be taken care of. Applications would be filed in appropriate courts for early hearing. If suppose DJ is not offering, we can go to High Court to get an early disposal because that is interest burden is there. So we have to take proactive actions on these and have to monitor these cases. Now we have engaged one agency for litigation management system. The person would be there, so he will keep a track of all these things. He will give you the details, which cases are pending, what action we are supposed to take, that has been taken or not. So we have to keep a tag. We have started this portal. Now automatically in most of the cases, they have come on disposal stage or everybody is saying these cases have been disposed of. Recently we have collected data, 36,000 cases have been told to be disposed of. So that's why the whole issue is monitoring itself. Once we monitor, we will get the disposal.
So next issue, what is this patent illegality? Means is violation of any fixation in market value by the Kala is a violation of legal provision or not? So what my advisor is saying, if it is, and district courts have observed that this is not a violation. If it is not a violation, then necessarily we are going to the district court. Then we should accept it. Any advocate can throw light on it. I also don't understand what is patent illegality.
Like compliances and all. It's not on the merits or the facts generally.
Okay.
Generally, courts, what the Supreme Court observed is the patent illegality is not on the prima facie and looking on the award, on the face of the award, it should appear that there is a grave error appeared. There is a grave discussed. In every case, they have given the instances, they have generally a prudent man would have not taken that kind of call. So it should be a root cause of, it is hitting the root cause of the particular matter. Saying that is like looking at the award, yes, it is a wrong award. That feeling should appear. Like that is what precisely been observed by the Supreme Courts in the latest decisions about the patent illegality. Unless until we prove that, the courts will not accept. But basically, primarily when we talk about the facts of the case, like for example, so this particular area is an underdeveloped area, we cannot give house sites value. So if we say that, there are many judgments where it tells the reappreciation of evidence is not permissible. Once the arbitration proceedings is completed, once the arbitrator decides that it is an underdeveloped or it is a house site, so we should not at the stage of district court or the high court under section 34 and 37, the court should not look into that. Reappreciation awards are not permissible. So there is a very clear observation by the Supreme Court. There we are stuck, like when we are proving it to the district court judges or the high court judges, we are not allowed to look into the facts. We are only allowed to discuss about the statutory provisions, what the particular arbitrator missed about. And section 28, class 7 of right to fair compensation, where it gives ample of...
for example, it is a agricultural land. Kala is giving house site, no documentary evidence, no conversion orders. Then if district court is not seeing all these things, high court is not seeing, and it is arbitration award, then where we will go?
No, it's not that, it's not looking at such. So basically in the district court and high court, like practically what I observed is, they are looking this as a beneficial legislation. So from that angle, the sympathy on the soft corner is always there for the land loser. So from that angle, the judges are looking at. It's not that what you are saying is always right. Like sometimes it's happening that the other side also, because very recently for Tirupati case, we have got a very good judgment from the district court where, yes, he agreed to my affidavit and gave the favorable judgment there. One of the instance. So it depends on the judicial officer, the perspective of the judicial officer from that angle. So when the courts are very clear saying that the arbitrator, whatever arbitrator decided basing on whatever he, the evidences, documental evidences, he already have gone through that. So don't go through that again.
No, but if he has not gone through any documentary evidence, no documentary evidence at all, then?
So when the evidence is not at all considered, then there is a permissibility. But if the particular documentary evidence is being recorded in the arbitration order, then the courts are reluctant to look into it again. So when so the particular documentary evidence, we have to prove that it is not there, it's not discussed in the arbitration order. Then courts are ready to look into it.
Okay, thank you.
Accordingly, it is dismissed and arbitrator award is upheld. So they cite standard citations of Supreme Court judgment, this and that. They said whatever arbitrator has done, this is discussed like this. So we need not interfere in this. So it is accordingly upheld.
Oh, that is all are managed orders.
No, no.
All are
Even
managed.
if there are merits, sir, I feel the court is not inclined to go into that.
It depends on judge. Judge is not listening us. Otherwise, if any arbitrator is giving any order treating agricultural land as house site or fit for house site without any documentary evidence, arbitrator is not having absolute powers. Or Kala is not having absolute powers going to the site and saying.
Sir, it is not a patent illegality, sir. Whatever arbitrator is doing, as you explained, sir.
वो तो कह रहे हैं तो वही तो issue है ना.
Yes.
Anyway, High Court. These are the 4 points. What steps can be taken to avoid delay in challenging district court's order in high courts within a mandatory period of 90 days? What step can be taken for early vacation of interim orders so as to remove the hindrances at site? What action to be taken to avoid personal appearance of senior officers? Sometimes I have also appeared in the court. Prompt attendance of the standing counsel in High Court whenever NHI cases reaches the bench to avoid unnecessary embarrassment to the concerned officer who are being asked to appear in the court. I have also once appeared in the court because my advocate has not appeared 2 or 3 times and there was a chances of adverse orders. So all these things, my advocates, please be careful. Last time also I have requested you. Such situations should not come. If we are not having time or we have multiple cases, you can send some junior also. At least we have to take some time. One more issue. High Court is reserving the orders, but not delivering the judgment. How we can pursue it?
Recently, there is a judgment from the, there is a circular from the Supreme Court. There is instruction saying that within 6 months it should get, that particular judgment should get delivered once it is reserved.
So now I think some Supreme Court...
Almost it is clear, like the stand is very clear. Now it will not, it
may
not repeat.
So it will be applicable for at least 2-3 months time or 2-3 years? No, otherwise again people will forget, all judges will forget this order.
No, positively thinking like it's...
Because in government also what's happening, some new circular comes, after 2-3 years we forget it.
It's not a circular, it's an observation by the Supreme Court and it's like an instruction to the High Court judges.
So let us see, let us see.
Hopefully this will answer our particular...
But this report will be sent for 3-4 months only. Then every registrar will also forget. Chaliye, anyway, something has happened. That's good. Because in one of the case, judge has delivered after 1.5 years. In 16 months, in Rajmundry case. So, देखो, this is a national highway. This is one of national importance infrastructure project. इसमें भी judges serious नहीं है. So how we can construct the road and give it to the public? Anyone else? Yes, in past we have done like that only. My advocate has given in some request during lunch motion and also have met judge in person in his chamber. So somehow we got the order, but after 16 months time. Okay, thank you very much. This has been very interactive session. Today we have learned a lot, and hope again next year we will meet. Thank you all. Thank you very much. Thank you my headquarter team, taking much pain and coming to Vijayawada and explaining the things, educating us. We have learned today so many things. We will learn tomorrow also. Thank you. Thank you very much.